court, my lord, I appear for the state in this matter.
Yes,
McDonald's
Mr.
initial D.
MacDonald.
May it please the court, my lord, I appear on behalf of the Haffejee family. My initials are AS, surname is Jessup, Jessop.
Yes. Mr. Varney didn't attend with you today.
I beg your pardon? No, my lord. My learned colleague, Mr. Zach Suleiman, is here with me as well.
Oh, okay.
Thank you, my lord.
Please pass the copies of the judgment to counsel.
May it please the court, my lord, I appear for Mr. Mohan.
Thank you. Thank you. How many? 4.
Thanks.
Yes. The late Dr. Hoosen Haffejee, in brackets Hoosen, who was 26 years old, died at the hands of the then South African Police Security Branch in the police cells at Brighton Beach Police Station, Durban, on 3 August 1977, allegedly from suicide by hanging. The pain of his sudden death reverberated within the heart, mind, and soul of his loving family in Pietermaritzburg. The ever-lingering melancholy felt by his mother, Mrs. Fatima Haffejee, is captured in a witness newspaper article of 17 July 1978 as follows, and I quote, "On Monday morning, August 1, 1977, my son wished me goodbye, saying that he would see me on Friday, as he usually came home every Friday since his return from India 22 months ago. My son was a very home-loving person, so he spent 3 days a week at home and would leave early on Monday morning for work in Durban. So as usual, he left home on Monday, August 1. God knows what happened to him. In August 3, 1977, we heard that shocking news. He had died in police detention. I could not believe that as my child was no criminal or terrorist. He was a noble young man, a dedicated doctor, but the police found him a dangerous terrorist. What damage had he done, or whom had he killed in order to warrant such suspicion? As a sensitive mother who shared a close relationship with her son, I knew that my son was not involved in any political activity, but rather was a carefree person. The police say that he was a brave man. Yes, he was brave because he was honest. They also said that he was desperate. Yes, because he was in a lion's den with no way to escape and no chance of informing his family of his detention. After his death, they said they found him hanging in his cell, but I'll never believe that my son took his own life. The security police then went to search his flat for about 2 hours, and what did they find? Just two ordinary letters from his friends in India. These were obviously a poor attempt to gather 30 bits of evidence as a means to disguise the main issue, that is, how and who inflicted these injuries on my son's body. Although a magistrate's findings are based on the evidence put before him, isn't it strange to find a recurring similarity in the injuries and bruises found on the bodies, of dead detainees and no evidence led about the obvious injuries. Are we doing enough to see justice being done? The Prime Minister was quoted in the Natal Mercury, May 25, 1978, confidently stating that, open quote, God will open doors to us so that we can fulfill our destiny, close quote. I think the time is right for us, the blacks, to pray that God will open a door to protect our destiny from the cruel injustice of the South African Security Police. I hope our prayers are answered before it is too late for us all. As a grieving mother, I cannot forget this terrible ordeal. My heart will always cry for my son, close quote. In a number of subsequent newspaper articles, Fatima made her feelings and suspicions regarding her son's death known. In 1997, she appealed to the Truth and Reconciliation Commission to put an end to her 2 decades of pain and suffering, stating, and I quote, "I know the truth about how my son died is going to come out one day. I want to know the truth about how my boy died. I'm very heartsore, and I will not rest until I find out who the killers are. I'll never, never believe my honest, home-loving, and caring son took his own life," close quotation. The TRC concluded that it was likely that Hoosen died under torture. Hundreds of TRC cases in which amnesty was not applied for or denied were referred to the National Prosecuting Authority for processing in terms of the law and the Constitution. The Haffejee case is one such matter. Fatima died in 2011 without knowing the truth of how her son died in police custody. Her daughter, Sarah Bibi Lal, and son Ismail Haffejee continued with her struggle for truth and justice. Since the winding up of the TRC proceedings, there has been inordinate delays in the pursuit of justice in the Haffejee matter, like I'm advised in many other kindred cases, and Hoosen's family was left in limbo for years on end. It appears that until recently, there was a state reluctance and or suppression to prosecute such matters. In Rodriguez versus National Director of Public Prosecution and others, the Supreme Court of Appeal strongly expressed itself thus, and I quote, "The executive adopted a policy position considered by the state parties that TRC cases would not be prosecuted. It is perplexing and inexplicable why such a stance was taken both in the light of the work and report of the TRC advocating a bold prosecutions policy, the guarantee of the prosecutorial independence of the NPA, its constitutional obligation to prosecute crimes, and the interests of the victims and survivors of the crimes," close quote. I'm advised that most of these cases cannot be revived. Suspects, witnesses, and family members have died. This inquest has come late for Hoosen's parents and his elder brother Yusuf. It seems the harm visited upon the Haffejee family and other families is incalculable and unforgivable. I'm also advised that it has been hard coming for the Haffejee family to reach this formal stage of the reopened inquest. On 29 July and 15 August 2019, the lawyers acting on behalf of the families of late Neil Agat and Haffejee threatened the Minister of Justice with an urgent High Court application if it did not instruct the judge presidents of the Gauteng and KwaZulu-Natal divisions to reopen the inquest. On 16 August 2019, the Minister of Justice released a press statement announcing that the inquests into the deaths of Agat and Haffejee would be reopened. James Taylor, the last surviving alleged lead interrogator and torturer of Hoosen, died 3 days later on 19 August 2019. Inquests, including reopened inquests, are regulated by Inquest Act. Section 17, capital A1 of the Act provides as follows, and I quote, "The Minister may, on the recommendation of the Attorney General concerned, at any time after the determination of an inquest, and if he deems it necessary in the interest of justice, request a judge, President of the Supreme Court, to designate any judge of the Supreme Court of South Africa to reopen that inquest, whereupon the judge thus designated shall reopen such inquest," close quotation. Section 17, capital A2 of the Act further states, and I quote, "An inquest referred to in subsection 1 shall, subject to provisions of this Act, as far as possible, be continued and disposed of by the judge so designated on the existing record of the proceedings, and the provisions of section 17(2) shall, insofar as they are not contrary to the provisions of this section, shall apply mutatis mutandis to such inquest," close quote. Section 17, capital A3B provides that, and I quote, "A judge holding an inquest that has been reopened in terms of this section shall record any finding that differs from a finding referred to in section 16(2), as well as the respect in which it differs," close quotation. It is apposite to record that the original record from the first inquest is incomplete in the reopened inquest. This court needs to consider the record of the original inquest. During the hearing of the reopened inquest, family handed up a list of exhibits produced at the first inquest. In this list, it was disclosed that approximately 66 exhibits were handed up and made part of the record during the first inquest, and of those 66 items, only the following exhibits are before this court. A, Exhibit C1 to C10, which are photographs of the different injuries on the body, legs, back, lumbar area, and arms of Hoosen. B, Exhibits N1 to N19, which are photographs of Hoosen taken during Dr. Big's examination of his injuries at his home before burial. Exhibit O.1, which are photographs of the injuries of Hoosen's legs. D, Exhibit DD, which is a statement of Gilbert Oliver Hughes, Senior Professional Officer, Chemical Laboratories of the Department of Health. E, Exhibit E, which is the statement of Ivor Colin White, Chief Professional Officer, Chemical Laboratories of the Department of Health. F, Exhibit FF, which is the identification of body form and statement by Yusuf. And G, Exhibit GG, which is a statement of Sergeant Richard Philip Law, South African Police Medical Legal Laboratories. The investigating officer, Warrant Officer Khamanyane, received the index findings of Magistrate Blunden and 2 versions of similar portions of the first inquest record from Hoosen's sister Sarah around February or March 2018. The index is in manuscript and contains only the details of the transcripts from the first inquest. Khamanyane further confirmed in his evidence in chief that some exhibits from the first inquest were indeed missing. These exhibits are categorized as follows: statements of Professor Iso Gordon, Chief State Pathologist Durban, Lieutenant James Broad Taylor, Captain P.L. Dutoy, handwriting expert, Warrant Officer Pretorius, Major Van Eeden, Constable Johannes Nicholas Meyer, Uniform Branch Member stationed at Brighton Beach Police Station, Constable Hugh Derek Node, Uniform Branch Member stationed at Brighton Beach Police Station, Constable Shadrach Madlala, Uniform Branch Member stationed at Brighton Beach Police Station, Captain H.L. Shourie, Scorey, Station Commander at Brighton Beach Police Station, Richard Brown Clark, Major Skete, investigating officer in the first inquest, and a written statement prepared by agreement between Dr. Simon, Dr. Clarkman, and Professor Lobsher in the presence of Dr. Lawrence. Also a report by Professor Gordon for blood or alcohol, barbiturates, nail scrapings, and for traces of marijuana or dagga analysis. Photographs of Hussein's vest, Hussein's shirt, Hussein's jacket, and photographs of the scenes of alleged events, such as the point of arrest, the parking area in the North Pier, and the pier itself. Also diagram of the cell and courtyard at Brighton Beach Police Station. Also request by Brigadier Lothar Nietling for analysis of the presence of human blood on pieces of clothing cut from Hussein's clothing, and a key to the list of pictures. Also a videotape of Nietling reconstructing the hanging of Hussein. Also missing documents, a booklet titled Our Immediate Task, which is described as an organizational guide referenced by Magistrate Blunden as one of the photostats of the documents that had been temporarily abstracted from Haffejee's flat. Also an article titled Histopathology of Healing Abrasions by Robertson and Hodge. Also a pamphlet titled Man's Worldly Goods by Leo Nuberman. 3 handwritten documents, the contents of which are not described. A document allegedly on explosives. Also clothing of Hussein, such as his underpants, trouser, vest, handkerchief, powder blue safari suit top, pair of shoes, pair of socks, and pieces of clothing cut out for the purposes of examination. Section 17, capital A2 of the Act requires a record of the proceedings as far as possible to be placed before a court for inquest proceedings to be reopened and concluded. However, the Act does not prevent an inquest judge from making a finding in the absence of a complete record. The Act only requires that the record of the proceedings be supplied as far as it is possibly can be supplied. The record in these proceedings, to the extent that it can be supplied, is already before this court. In addition, the first inquest record has been supplemented by considerable new evidence which would be of assistance to this court. In S versus Chabedi, the Supreme Court of Appeal held as follows regarding the adequacy of records, and I quote, "On appeal, the record of the proceedings in the trial court is of cardinal importance. After all, that record forms the whole basis of the rehearing by the Court of Appeal. If the record is inadequate for a proper consideration of the appeal, it will, as a rule, lead to the conviction and sentence being set aside. However, the requirement is that the record must be adequate for proper consideration of the appeal, not that it must be a perfect recordal of everything that was said at the trial. As has been pointed out in previous cases, records of proceedings are often still by hand, in which event a verbatim record is impossible." The question of whether in a record are so serious, whether defects in the record are so serious that a proper consideration of the appeal is not possible cannot be answered in the abstract. It depends inter alia on the nature of the defects in the particular record and on the nature of the issues to be decided on appeal, close quotation. It is tried that a party to any litigation proceedings must produce the original documents in court. The reason for this is that errors may be made in subsequent copies or documents may be falsified. However, a party need only produce the original document when the contents of the document and not the actual existence of the document are in dispute. In Wells and another versus Hall and others, where Conradi J. held, and I quote, "As far as the best evidence rule is concerned, it is a rule that applies nowadays only in the context of documents, and then only when the content of a document is directly in issue." Close quotation. Copies of the original may be admissible if it can be shown that the original has been destroyed or that despite a diligent search, the original cannot be located. In this reopened inquest, the only concern is the availability of some documents from the original inquest. Otherwise, none of the parties have raised a dispute regarding the contents of the available documents. To the extent that the above principle can be applied to inquests, I believe that the available portions of the record, as supplemented by the considerable body of evidence adduced in the hearing, are more than sufficient for a proper consideration of this reopened inquest. I'll now deal with the life history of Hoosen. Hoosen was born on 6 November 1950 in Pietermaritzburg, KwaZulu-Natal. He had 3 siblings, Sarah, Ishmael, and Yusuf. His father, Mohammed Hoosen Haffejee, died on 8 May 1986, while Yusuf died on 16 September 2009, and his mother, Fatima, died on 16 April 2011. Hoosen's political activities were not known to his family. His early life meshed with the politics of the day. According to the evidence of the anti-apartheid activist Hanef Pamji, as early as in 1960, when Hoosen was 10 years old, he was already an active body on the streets and was keen to be involved in the struggle for freedom. They developed a close relationship from those days. It was in the same year that the African National Congress and the Pan-Africanist Congress were banned by the National Party government. Pamji gave elementary Marxist books and pamphlets to Hoosen to read. Pamji wanted to strengthen anti-apartheid groups and spoke to Hoosen about the activities of Umkhonto weSizwe, the armed wing of the ANC. In 1961, while in primary school, Hoosen met K.V. Moodley, who would later become a close comrade. In 1962, Moodley became Pamji's first recruit. He worked closely with Hoosen and the ANC Youth League. Later that year, Moodley was recruited into Umkhonto weSizwe. In 1963, Pamji invited 13-year-old Hoosen to join his study, invited quote-unquote study group 29, which was a political education group. According to Moodley, Hoosen was one of the youngest who were attending the youth group. They met in Pietermaritzburg Library. The group worked with the Natal Indian Congress. According to Moodley, it was generally understood that he and Hoosen were members of the ANC and the South African Communist Party. Between 1962 and 1964, multiple arrests of political activists were taking place. At the study groups during this time, Pamji explained to Hoosen and others that it was not the time to engage in sabotage, even though they had some knowledge of explosives. Hoosen's early commitment to the struggle was highlighted by Pamji. Around 1963 or 1964, Hoosen, Moodley, and Pamji organized a petition asking for a swimming pool for people of color. In 1965, after Moodle moved to India and began his own study group, Hoosen, Bamji, and others organized a boycott of the royal show because management said that they would, open quote, limit the numbers of non-white children because of serious overcrowding by them in previous years, close quote. In August 1965, Bamji left for the United Kingdom. In June 1968, a few months before Hoosen turned 18, he traveled to Bombay, India, to study for a pre-medical degree at Bhavna's College. He traveled and started the pre-medical degree with Kromsam Nonkumar and Abdul Kader Aku. Hoosen, Nonkumar, and Aku opted to study medicine in India because of the limited opportunities available to people of color to study at medical schools in South Africa. Aku took part in activist movements with Hoosen when they arrived in India in June 1968. They were roommates in the hostel. According to Aku, Hoosen was a determined anti-apartheid activist. He said Hoosen was widely read and he embraced socialism and communism. While in India, Hoosen began receiving copies of Sechaba, the newspaper of the Umkhonto weSizwe. The newspaper was addressed to Aku. Aku suspected that it was Hoosen who was behind him receiving this newspaper. He recalled an event when their hostel was raided by right-wing nationalists. Hoosen, open quote, galvanized them into producing petrol bombs, which they used to successfully thwart the mob when they attempted to repeat their shenanigans, close quote. Hoosen and Aku met with ANC representatives in India. They had lunch with Moses Mullah and met with Mr. Ghulam and Mrs. Amina Bahad. At these lunches, students were lectured and persuaded to join the ANC. It was around this time that Aku suspected that Hoosen had joined the ANC, although Hoosen would never speak about his affiliation or membership because of the risk of being exposed to the apartheid police. It was something you kept to yourself, Aku said. In 1968, Hoosen reunited with Moodley, and Moodley recruited him into his study group. Hoosen participated in all the activities, including the study of, open quote, political systems, theory of guerrilla warfare, sabotage, and practical application of underground work, close quote. In June 1970, Hoosen was not accepted into Natal University's medical school, and he decided to pursue dentistry. He moved to Nagpur, India. In January 1971, he met Vinay Hazare at the Government Dental College where they were both studying. In 1971, Hoosen met Fatima Sakur and A.B. Gangat, who were also studying dentistry, and they developed a friendship. According to Sakur, Hoosen was knowledgeable about the politics of the South African struggle. They spoke much about struggle icons such as Yusuf Dadoo, Ishmael Kachalia, and Nelson Mandela. Between 1973 and 1974, Hoosen was the General Secretary of the Dental College and Hospital Student Association and became its president during 1974 and 1975. Going back to 1973, he became a member of the Bombay ANC cell structure and attended ANC/SACP training school in Bombay. According to Bamji, these structures discussed the history of South Africa, Marxism, Leninism, underground work, and urban guerrilla warfare. All who went through the training were asked to consider smuggling the information back to South Africa by having it reduced to tiny print and then sewn into lining of their clothing. According to Pamji, Hoosen must have taken his original notes to South Africa because they were exhibited at his first inquest. However, these notes were not available at the time of the reopened inquest. Pamji said that he learned from Yusuf and Motley about these notes at the first inquest. According to Pamji, this was a serious mistake by Hoosen, which was contrary to the agreed security measures. In 1976, after qualifying with his degree in dentistry, Hoosen went to London to see his aunt, Rabia B. Rahim. He thereafter went to Cardiff to see Pamji. While there, and around August 1976, he and Pamji attended the ANC/ACCP training school in Dublin, Ireland. In September 1976, Hoosen completed his studies and left India to practice dentistry in South Africa. On his return, Hoosen began working in Durban at King George V Hospital. In January 1976, he met Miss Mathivatini Govender. At the time, her surname was Govender, which changed after she married Major Joseph Benjamin. She was a nurse or a dental assistant at the hospital. Around March 1977, she started a relationship with Hoosen. Miss Benjamin admitted to being quite taken by Hoosen. She considered the relationship as not exactly romantic, but admitted that she did harbor deep feelings for him. According to her, from Hoosen's perspective, he did not see the relationship as a serious one. This was because he had an interest in another woman who happened to be a Muslim. Miss Benjamin found this to be insulting and hurtful. She became upset that Hoosen was not as responsive to her as she would have liked him to be. Miss Benjamin stated that Hoosen's intention was to have a cell or group where he could influence and promote his beliefs. He would have meetings with young students at his flat for the purpose of recruiting them and teaching them how to be an activist. Miss Benjamin testified that she did not support Hoosen's recruitment of people to fight against apartheid. She claimed that Hoosen thought he was better than everyone else. When questioned about this, however, she considered that she wanted Hoosen to suffer a little because of his interest in another woman. She also considered that her working with the security branch was to make Hoosen suffer for what he did to her, not for any public good. In a statement, Ms. Benjamin stated that while cleaning Hoosen's flat, she came across subversive literature on how to train communists. In oral evidence, she changed her testimony and considered that she was not cleaning, but in fact snooping around to find potential material to implicate Hoosen to the security branch. According to the former security branch officer, Mohan Deva Gopal, Ms. Benjamin called the switchboard at Fisher Street, and her call was transferred to Captain Petrus Lodevicus Dutoy. She informed Dutoy about a doctor involved in manufacturing of chemical bombs. She advised that she was fed up with him because he was involved in a relationship with her and a Muslim woman. She was very bitter and wanted to get back at him. The security branch officers met Ms. Benjamin at Delhi restaurant under the command of Dutoy and on instruction of Major Joseph Benjamin. Gopal was accompanied by Warrant Officer Virara Kululu Naidu, amongst others, who went to meet her. V.R. Naidu, Sergeant Shanmugan, or in brackets Schroed's governor, and Gopal walked into the restaurant to meet her. They took her to Fisher Street in their vehicle. She was taken to Tutoy's offices, where she was questioned by Tutoy and Major Benjamin. Gopal was part of the meeting, and he testified that the security branch received extensive information about Hoosen from Miss Benjamin. According to Gopal, he and members of the security branch had never heard of Hoosen prior to receiving information from Miss Benjamin. After meeting with Miss Benjamin, approximately the next day or so, Major Benjamin spoke to Tutoy about hot wiring Hoosen's flat. A tamati was placed in Hoosen's flat by Lieutenant Vic McPherson and Schroed. A tamati was how the security branch referred to a concealed listening park. The security branch had access to Hoosen's flat through the keys provided to them by Miss Benjamin. The security branch made copies of the keys. Hoosen's home and place of employment were tapped. It was then decided to observe Hoosen for 24 hours round the clock. They had 6 teams. VR Naidu was part of one team. At some stage, Schroed and Major Benjamin gained access to Hoosen's flat with the keys provided to them by Miss Benjamin. Papers in the flat were photocopied and the originals returned. Miss Benjamin remained in contact with the security branch and gave them feedback on what was happening every 2 or 3 days. Miss Benjamin advised Gopal and the security branch that Hoosen gave lectures to Muslim students every Thursday evening at his flat and taught them how to manufacture bombs. Based on this, the security branch concluded that Hoosen was lecturing on manufacturing explosives. Surveillance went on for approximately 4 months, beginning in April 1977. Gopal listened to the conversations that took place in the flat. He had a special interest in Thursday nights because those were the days that Hoosen held lectures for 2 Muslim men from Potchefstroom between 2000 hours and 2200 hours. He claimed that he heard Hoosen giving lectures on the manufacturing of chemical bombs. Gopal was also tasked with observing who was entering and exiting Hoosen's home. Aku, a friend of Hoosen, remembers Hoosen telling him that he thought he was being followed while driving around Durban city areas. Aku knew that Hoosen had 2 romantic partners. He recalled that both lovers had keys to Hoosen's flat. Lieutenant James Bro-Taylor testified at the first inquest that he and Tutoy saw Hoosen drive past them in central Durban between 21 June and 5 July 1977. This seems to confirm that Hoosen was being monitored by the security branch. Moodley was at Hoosen's flat on 15 July 1977, when Hoosen received a phone call where he was, open quote, argumentative, dismissive, and most of the time rude, close quote. After Moodley inquired who the caller was, Hoosen said it was Miss Benjamin. According to Moodley, Hoosen advised him that Miss Benjamin was upset since she found out that he was courting another woman, a Miss Shaider, who was a student at University of Durban, Westville. Moodley expressed his concern at the state of Hoosen's relationship with Miss Benjamin, as this could impact on their political work. He said he told Hoosen that, and I quote, complications from a scorned ex-girlfriend were unnecessary, close quotation. Hoosen agreed. Miss Benjamin said she last saw Hoosen between 23 and 26 July 1977, before he died. On Sunday, 31 July 1977, and on his return from a trip to Mumbai, India, Moodley was visited by Hoosen at his parents' home in Pietermaritzburg at around 1600 hours. Hoosen informed him that a colored nurse who worked with him informed him that she overheard Miss Benjamin reporting his political activities to the security branch. Hoosen told Moodley that he was, and I quote, not worried, nor was he scared, and certainly not suicidal, but only looking for advice, close quote. After discussing the matter, the two agreed that Hoosen should leave the country. Hoosen told Moodley that he would inform him once he is out of the country. Between 1 and 2 August 1977, while Moodley was on emergency call at hospital, he called Hoosen several times, but there was no answer. Moodley said he assumed, erroneously, that Hoosen had left the country. Going back, after meeting Moodley, Hoosen went to his family home in Pietermaritzburg. According to Sarah, he was, quote-unquote, in good spirits and was playing with his nieces and nephews. On that Sunday evening, 31 July 1977, Hoosen visited his brother Ishmael at his home in Loop Street, Pietermaritzburg, and played Scrabble with Ishmael's son. He left around 2200 hours to go back to his parents' house in Church Street, Pietermaritzburg. Hoosen then returned to Durban. He left Pietermaritzburg for Durban on the morning of 1 August 1977, between 600 hours and 6 hours 30 in the morning. In the evening, Aku, Nankumar, and Hoosen had dinner at Hoosen's flat. The three friends spent time, quote-unquote, reminiscing of the past. On 2 August 1977, at around 600 hours, Tutoy called his unit members and explained that there was enough to conclude that there was sufficient cause to arrest Hoosen for the purpose of interrogation. Gopal considered in cross-examination that he could not state whether there was enough evidence at that stage against Hoosen to secure a conviction. Gopal testified that around 6:30, Tutoy commanded his unit to get all their cars lined up, as when Hoosen left his flat, they were to follow his vehicle and come to a specific point where they felt it was safe to have him arrested. Tutoy led the line of vehicles with Taylor, then Gopal and Schultz, and then V.R. Naidu and McPherson at the end. Between 7:47 and 800 hours, Hoosen was forced off the road and arrested by Tutoy, Taylor, McPherson, Schultz, Benjamin, and Gopal. According to Gopal, the apprehension of Hoosen amounted to a kidnapping. Hoosen's vehicle was forced onto a grassy patch. The unit members alighted from their vehicles. Taylor was the first to open Hoosen's car door and pull him out of the vehicle. Contrary to Tutoy and Taylor's evidence in the first inquest, Hoosen did not resist arrest and was not injured in any way at that point. Gopal stated that the evidence of Tutoy and Taylor in the first inquest that a scuffle took place was a lie. Hoosen was handcuffed and placed into Tutoy's vehicle. Hoosen was not informed of any charges against him and was not given any procedural warnings. Hoosen was then taken to the Brighton Beach police station. Gopal considered that upon reflection, Hoosen was taken to Brighton Beach police station rather than Fisher Street security branch offices in downtown Durban, to make sure nobody would know that he was being abducted. Brighton Beach Police Station is located quite far from the city center in the quiet suburb of The Bluff. Gopal continued. They reached Brighton Beach Police Station at approximately 9 o'clock. It took approximately an hour to get from Overport to Brighton Beach because of heavy traffic. Hussein was not booked in at the church office, but was taken to a basement which was used as an interrogation room. Gopal noted in cross-examination that upon reflection, Hussein was taken to the basement so that the sound could get drowned out, since things could get, quote-unquote, a little messy. The court took time to conduct an inspection in loco of inter alia, the possible interrogation room at Brighton Beach Police Station, on 18 August 2021. The room is situated in the basement of the multi-story building, which contains police barracks above it. Access to it is isolated and can be gained through a separate driveway on the southwest side of the building. At the time of the court's visit, the room, which was identified by Gopal, was clearly neglected, degraded, flooded with stagnant water up to one's ankles, and was filled with mosquitoes. It was unused at the time and had apparently been so for many years, according to Captain Kruger, the current commander of the police station. According to Gopal, the purpose of the interrogation was to firstly find out who the two Muslim men were that attended Hussein's lectures, and secondly, to find out more about the training he had received in India. Gopal stated that the first 24 hours of the interrogation were the most important, and as a result, were the most intense. This was for purposes of extracting information that could lead to the capture of other suspects before they got wind of Hussein's detention. Gopal's evidence was that he was instructed to give Hussein food, escort him to the toilet, and make sure he did not escape. Taylor and Schultz were the initial interrogators. Tutoy was also in the room, and Major Benjamin intermittently entered and exited the room. Hussein was first asked about his background and his training. He was also asked about the lectures he was giving every Thursday night. Hussein was asked to get out of his blue-gray safari suit and was left with his white underpants. Gopal considered that the purpose of stripping a suspect was firstly not to leave bloodstains on the clothing, and secondly to humiliate him. Hussein was questioned by all the members of the security branch. The assaults began around 9:15 or 9:20. Taylor initiated the assault by slapping and punching Hussein with open palm slaps, kicks on his kidney, along his back and front, and on his legs and thighs. The punches became more violent through the course of the day. Tutoy also started assaulting Hussein, hitting him on the legs, ankles, private parts, buttocks, back, face, neck, arms, and armpits. The torture stopped temporarily around 1400 hours as the security branch members, quote-unquote, broke for lunch. Colonel Ignatius Gerard Kutsie, who was second in command of the Durban security branch, arrived and asked Gopal to assist Hussein in putting his clothes back on. Hoosen could not bend because his entire body was sore. After lunch, Taylor resumed the torture, but this time more intensely. Hoosen was already bruised all over his body, but not bleeding. Gopal could see the marks all over his body, as Hoosen had quite fair skin. Gopal said that Taylor dragged Hoosen by the back of the neck to the toilet and made him drink the water from the toilet. Hoosen was struggling to breathe and resisted by pushing himself up. As a result, he fell back and hit his head against the wall and fell on the ground. Hoosen was then dragged back to the interrogation room. After this episode, the assaults continued. Hoosen still did not disclose any information or anything that constituted intelligence. At this point, the security branch had no evidence that would secure a charge. Gopal testified that the claim by Tutoy that Hoosen was taken to Durban Bay where a scuffle broke out was a lie, put forward at the first inquest to explain the injuries on Hoosen's body. Gopal initially denied being part of the interrogation, but later conceded under cross-examination that he was and that he did ask Hoosen one or two questions. Gopal left the police station, or should I say the interrogation room, at some point to go to the shops to get lunch. When he returned, he observed Hoosen being assaulted again. Hoosen collapsed on the floor after his face hit a pillar as Taylor was kicking and pushing him. Hoosen was confronted with the documents retrieved from his flat. He was also confronted with the recordings obtained from the Tamati. According to Gopal, and contrary to Taylor's evidence at the first inquest, he was confronted with these documents throughout the day and not only at 2300 hours. Gopal stated that the torture concluded at around midnight because the interrogators were quote-unquote tired. The security branch officers put Hoosen's clothes back on and Taylor brushed his hair back. Taylor took a towel and wiped blood off Hoosen's lip. According to Gopal, Hoosen was then taken to the charge office by Schroet, Taylor, Tutoy, and himself. He said Hoosen walked very slowly but walked upright for a short while before bending over again. He claimed that Hoosen did not have to be carried to the charge office. Gopal denied Taylor and Tutoy's version at the first inquest that he, Schroet, and McPherson were out doing further investigation at the time and were then called back via radio to Brighton Beach and only then escorted Hoosen to the charge office. In cross-examination, it was put to Gopal that the reason Taylor and Tutoy presented such fabricated evidence which removed them from the scene was because Hoosen was either debilitated and could barely move, or he was probably dead by that time. Gopal denied this. He testified that Hoosen was most likely killed because dead men, quote-unquote, tell no tales. However, he denied that Hoosen died under interrogation. This contrasted with the expert evidence of the pathologist, Dr. S.R. Naidu, who concluded that Hoosen would in all probability have been dead by this time. According to Gopal, Hoosen was then booked in by the church office sergeant. It was not disclosed to the church office staff that Hoosen had sustained injuries. Gopal testified that Taylor told Hoosen that if he disclosed his injuries, he would be taken back in for more questioning, quote unquote. He said Hoosen was trembling at the time because of how weak he was. Gopal disputed Naidu's evidence that if Hoosen was not already dead, he would have been in a lower state of consciousness. When cross-examined on the injuries to Hoosen's arm, Gopal stated that he did not notice any injuries on Hoosen's arms. This claim contrasts with the medical evidence to be dealt with below, which confirms injuries on the arms. Gopal was of the view that further torture must have taken place in the cell after he left. According to Constables Johannes Nicholas Meyer and Hugh Derek Nodier, uniformed branch members on duty that night at the church office, Hoosen was booked in injury-free and no one entered the cells after he was locked up. Gopal testified that if there were injuries on Hoosen's arms at that time, church office staff would have noticed and duly recorded this in the occurrence book. Gopal felt that the evidence of Nodier and Meyer ought not to be accepted because they would have collaborated with whoever inflicted those injuries on Hoosen in his cell. Meyer's account is as follows. Meyer gave a different version. According to him, on the night of 2 August 1977, he was on duty at the Brighton Beach Police Station's church office when Hoosen was brought into the church office before midnight. He was on duty with 2 other uniformed branch members, namely Nodier and Constable Shadrach Madlala. Meyer was on shift between 2200 hours and 6 the next morning. According to Meyer, Hoosen was detained as quote-unquote a political prisoner. Meyer testified that he was not aware that Hoosen had been in the building since early that morning. He was also not aware that any interrogations took place at the basement storeroom. He considered that it was irregular or even illegal for the security branch to bring a detainee to the basement storeroom for interrogation without doing any paperwork. He said that Hoosen was accompanied by 2 well-built white security branch members. He could not recall any Indian members accompanying Hoosen. Hoosen was dressed in a short-sleeved safari suit and shoes and walked in quite normally. He described Hoosen as nervous and quote-unquote shaking a bit. Meyer claimed not to have seen any injuries or signs of assault or bruise marks on him at that stage. He said he asked Hoosen if he had any injuries, and Hoosen said no. Meyer considered that this was inconsistent with the evidence of Gopal that Hoosen was severely beaten. He also considered that his evidence was inconsistent with that of Naidu, who asserted that Hoosen would have been in great discomfort. At the church office, Hoosen then removed his trouser belt, shoelaces, and other items from his person, which were booked into the prisoner's property register. He said Hoosen removed these items himself in the presence of Meyer. Meyer asked Hoosen to finish a cool drink he was drinking, but the security branch members apparently countermanded him and said Hoosen could take it with him to the cell. Hoosen was then physically searched and was found to have no other property on his person. I'll pause there. We'll take a tea break to proceed at 11:30. Court is adjourned.
don't worry.
Just to know the name of the witness who says that she wanted to
It was the government. He came into the meeting. Yeah. I think maybe the third year. No. I'm actually
Coastal Government.
coastal.
Company Subramani. Coastal Government.
He was later appointed major. Security. I mean, kind of. No, bring all four. Yeah, a lot. When Pewa and Quebec were 19, Quebec and Pewa, 19, last possession. It's a pretty much what we didn't do. Let me question. Hey, I think that's going to be the
Yeah.
I proceed. Nodia's version dovetails with that of Myers. He was on duty on the night in question from 2100 hours to 7 hours the next morning. He said he was not aware of the fact that Hoosen was being interrogated at the Brighton Beach police station. In fact, he claimed that it was the first time he ever heard about this fact. According to Nodia, on this day at around midnight, 2 white plain-clothed men arrived at Brighton Beach police station, identified themselves as security branch members, and informed him that Hoosen was a political prisoner and nobody was allowed to communicate with him apart from the security branch members. Nodia said that Hoosen wore a trouser and a shirt. He claimed that Hoosen was quote-unquote in perfect health, but appeared to be looking tense. He considered that if Hoosen was wearing a short-sleeved safari suit and had sustained injuries on his arms, he would probably have seen such injuries. He said Hoosen was stripped of standard items specified for cell detention, he said Hoosen was stripped of standard items specified for cell detention at the time. These items are logged in the cell register and occurrence book, and Hoosen was then taken to the cells by Nodia and his colleague. In cross-examination, it was put to Nodia that it was the evidence of Naidu and Dr. Holland that Hoosen's time of death would have been at least by midnight. Nodia said that he did not know how that was possible because he saw Hoosen being taken to the cells. He agreed that it was not proper procedure to place Hoosen directly into the interrogation room without being booked in and filling out the proper paperwork. Gopal denied Taylor's evidence at the first inquest that he was not part of the group that escorted Hoosen to his cell. He insisted that he accompanied Hoosen to his cell. According to Gopal, Hoosen's injuries were noticeable as he had visible bruises and lacerations. At this time, he says, Hoosen was conscious and could walk very softly. While in the cell, Gopal claims to have spoken to Hoosen. He told Hoosen that he was getting a 2-hour break before the rest of the officers would be back. When it was put to Gopal that it was improbable that his evidence was correct, because it was the expert opinion of Naidu that Hoosen would have either been in a state of absolute distress and pain, or unconscious, or even dead. Gopal denied this and insisted that Hoosen was alive at the time and was able to walk from the church office to the cell. Gopal said that when he left the cell, Hoosen was still wearing the safari suit he had worn since the morning. In examination, Gopal said that the clothing Hoosen wore in the post-mortem images, the long-sleeve shirt, was not the same clothing he saw him in during the day of his torture, being a short-sleeved safari suit. Gopal claimed that the long-sleeved shirt was probably placed on Hoosen to hide his injuries. He claimed that this shirt must have been put on Hoosen after he left the cell. Maya states that around 2300 hours to 23 hours 30, Hoosen was escorted to a holding cell by himself and Nodia in the presence of security branch members. He claims that Hoosen was able to walk freely without assistance from anyone. After Hoosen was placed in his cell, the normal procedure of locking the doors was followed. According to Maya, the security branch members then left the police station, and the uniformed members returned to the church office. Contrary to Kopal's evidence, Notier said that he, together with a colleague and the security branch officers, took Hoosen to his cell. He could not recall any Indian members walking with him. He also claimed that Hoosen had no issue walking to his cell. According to Maya, the cells were inspected every hour in teams of 2. He claimed that on the first hour, he and a colleague visited the cells, which was most probably between midnight and 1 o'clock in the morning. According to Notier, after Hoosen had been placed in his cell, normal cell visits and procedures were adhered to for the remainder of his shift. These procedures included checking the number of prisoners and that cell doors were correctly closed. He said he would enter the cell to confirm this. However, no communication was made with Hoosen. Cell visits occurred every hour until 4 in the morning when Hoosen was discovered dead. Notier agreed that since it was not practiced to wake detainees during cell visits, there is a possibility that Hoosen could have already been dead during his prior visits. According to Notier, the last cell visit was at 6 on the morning of 3 August 1977. When it was put to him that his testimony at the first inquest was that he saw the dead body during his visit at 4, he said he was convinced it occurred prior to handing over to the next shift at 7, but considered that his memory might be shaky given the lapse of so many years. At just after 4 in the morning, upon opening the door, Maya claimed he noticed that something was abnormal about the scene. According to him, Hoosen was laying on the floor on his back. His lower body was naked, with something attached to his neck and tied around the bars of the quote-unquote safety gate on the inside of the cell, and the knot was tied very tightly in a Cook sister formation. On entering the cell, Maya says that he saw Hoosen's trousers tied around the bars of the safety gate with the leg parts twisted around his neck. According to Maya, no person was allowed to visit the cells. The officers in the church office held the keys. If any officer, including the security branch, issued a higher command to release the keys, he insisted that he would not follow the command. Instead, he would have escorted the security branch member to the cell. While Maya said he believed it was suicide, he considered that he could not automatically assume that it was in fact suicide, since there is evidence from other reopened inquests that other political prisoners would not have caused their own death. On the last cell visit, prior to handing over responsibilities to the morning shift, Notier said he found Hoosen lying on the floor of his cell with his head against the bars of the inner cell door. His trousers were threaded through the bars of the cell door and around his throat, twisted tightly, and his knees were pulled up towards his stomach. In the reopened inquest, both Notier and Meyer claimed that they were the first, with Madlala obviously, to discover Hoosen dead in cell number 2 on their visit at 4 in the morning, on the morning of 3 August 1977. In the first inquest, Notier testified that it was he who discovered Hoosen's dead body. After discovering the body, Notier contacted his immediate superiors, who took control of the situation, and they were instructed not to leave the premises until advised that they could do so. According to Maya, the security branch members, the station commander, Captain Potgieter, and standby criminal investigation department, warrant officer Bezaidenhout, were immediately telephoned. Other security branch members, such as Tutoy and Taylor, arrived on their own approximately 15 minutes later. According to Tutoi's testimony in the first inquest, Captain Shori took him to the cell. Then Colonel Stedler arrived with his former chief, Brigadier Steenkamp. Professor Gordon was then telephoned. According to Meyer, the security branch instructed the uniformed branch members to leave the scene. The security branch thereafter did their own investigations. It is not known what quote-unquote investigations were carried out by the security branch and who amongst them carried them out. But it would appear they entered the cell before the forensics unit carried out their duties. Tutoi, together with Taylor, were thereafter assigned to pick up Gordon. Meyer could not remember what time they picked up Gordon. We do, however, know that the examination in the cell occurred at 7 in the morning. The police investigation that followed can only be described as substandard. It appears it was largely designed to prop up the cover-up story of the security branch. More about this later in the judgment. Sergeant Richard Philip Law of the South African Medical Legal Laboratories, 95 Gale Street, Durban, removed Hoosen's body from Brighton Beach Police Station and transported the body to the mortuary. We do not know what time Hoosen's body was transported to the mortuary from the police station, but it must have occurred after Gordon conducted his examination in the cell at 7 in the morning. According to an interview by Christian DeFos of the University of Westville's quote-unquote Voices of Resistance oral history project, which he conducted with Yusuf on 25 May 2002, two white males approached him on the morning of 4 August 1977 and informed him that his brother had committed suicide. He was informed that a postmortem was going to be conducted and that he should phone Gordon if he wanted to know anything. Yusuf called Gordon's office and was advised that Gordon was already at the police mortuary in Gale Street and that if Yusuf wanted to have a doctor present, he should hurry because Gordon was going to start the postmortem. Yusuf called his friend, Dr. Yusuf Chenia, and asked him to be present at the postmortem and to arrange for a pathologist. Chenia could not arrange a pathologist to be present and thus attended the postmortem alone. The postmortem began at approximately 10:20. Chenia did not give evidence at the first inquest, nor was there any statement of his in the record or exhibit list. On 3 August 1977, Amene Motala, a friend of Hoosen and Hoosen's aunt Rahim, were dropped off by Amena's husband at a museum. Her evidence, contained in an affidavit filed of record, was that she was dropped off at the museum early in the morning by her husband, who was on his way to work. Her husband returned to the museum approximately 2 hours later and said that they needed to urgently go to the government mortuary in central Durban. The Motalas and Rahim attended the mortuary, where 2 white security branch officers were waiting for them. Amena spoke to these 2 officers, whose names she could not remember. She informed them that she was present to identify the body of Hoosen. Hoosen's body was then released and uncovered. Rahim was emotionally struck by Hoosen's injuries and left the room. Amena observed the following injuries: burn marks underneath the soles of his feet, which she believed could have been caused by an electrical instrument. Many bruises on his body and head, which she believed was caused by an assault, and his face was swollen. Amena confronted the security branch officers and said that Hoosen did not look like he killed himself. They did not respond, but gave her a quote-unquote bad look. Later that day, Yusuf identified the body and carried out Hoosen's Islamic burial rites. Hoosen's body was then transported back to Pietermaritzburg to be bathed according to Muslim tradition. Biggs was asked by the Haffejee family to examine the body at the family home in Church Street, Pietermaritzburg, at approximately 17:40. It is not clear whether this examination occurred before or after Hoosen's ceremonial bath. Dr. Chota Motala was also present. Biggs directed a photographer who took photos of the body. Ishmael removed the white calico covering, or kafan, and was shocked to see the condition of his brother's body. He recalls seeing the following injuries on Hoosen's body: bruises, most notable on the back and sides, brown dots that looked like the burns on his inner thighs and in and around the genital area, swelling of the face, and depressions in and around the wrists, underarms, and genital areas. With all these injuries, Ishmael believed that his brother had been tortured and, quote-unquote, could not reconcile hanging with these injuries. Ms. Hajera Bibi Subedar, Hoosen's maternal aunt, stated that at the funeral, she saw Hoosen's face and described it as swollen. When Moodley saw Hoosen's body, he, quote-unquote, noticed all the wounds, over 50, on his body. Some look like electric burns, and others where his skin appeared to have been removed by unknown instrument. His face and skull were also swollen and bruised. According to Sarah, Hoosen, as a young man, showed no signs of depression. She saw him during the weeks prior to his death, including the weekend before, and he did not seem any different. He was not displaying any signs of anxiety or stress. Sarah said that no one believed the police when they claimed that her brother had committed suicide. To her, it, quote-unquote, sounded bizarre because in the Islamic faith, suicide is not permissible. Hoosen knew about that principle. He knew that committing suicide was a sin and that if he did, he could not be buried in the designated Muslim area of the cemetery. Hoosen was, however, buried in the designated Muslim area of the cemetery because nobody in the community believed he had committed suicide. Ismail insisted that his brother believed strongly in the Muslim doctrine, that life is sacred, and it is only God that can take life away prematurely. It is well known to Muslims that if they take their own lives prematurely, it is a grave and unforgivable sin. Ishmael cited the Islamic doctrine that life comes from God, life belongs to him, and it is he who takes away life. According to Ismail, Hoosen had no health conditions and was very healthy. He said his brother, quote-unquote, was jovial before he left his house on Saturday evening before his death. He had, quote-unquote, no injuries or complaints. Aku last saw Hoosen when they had dinner at his flat on Sunday evening before his death. When he left Hoosen's flat around 22:30, he did not recall Hoosen being, quote-unquote, unhappy. Kopal claimed that he was informed of Hoosen's death by Taylor in the morning after his death when he bumped into Taylor at the Fisher Street offices. He then met Major Benjamin and asked him what had happened. Kopal says that Benjamin put his finger to his lips and told him to keep quiet. He says he had a bad feeling that Benjamin knew what happened but did not want to tell him. According to Kopal, on that morning, Tutoy called all the security branch officers who were present during the interrogation and said that they might be called to give evidence at the first inquest and that they should, quote-unquote, have their story prepared. The cover story was that Hoosen had confessed that there was a dead letterbox at the Durban Bay and that they had taken him there to point out where he had hidden documents on the manufacture of explosives, chemical bombs, and instructions on how to deal with interrogation. The interrogation team was told by Tutoy that he would be dictating to each member what they should say. Tutoy then called in each member one by one. Kopal was told that he would say he would have to say that Hoosen was not handcuffed and that he tried to escape. During this process, Hoosen got violent and had to be restrained, and in the process, his body struck various parts of the car. Tutoy gave Gopal a 4-track cassette on which to record his story. Tutoy also instructed Gopal and Macpherson to go to Hoosen's flat to remove the listening device, which was removed by Macpherson and Schultz. Gopal admitted that as a member of the interrogation team, he was willing to collude and lie so the truth could be swept under the carpet. Ultimately, Magistrate Blunden accepted the security branch's cover story and concluded that nobody was to be blamed for Hoosen's death. On 4 August 1977, the day after Hoosen died, a doctor from King Edward V Hospital called Saku to ask where her husband, Gangat, was. It appears Gangat had disappeared, which I'm told was unusual, as his car was still parked at the hospital. Later that day, Saku received information from her brother that a Mr. Farouk Mullah found her husband wandering around on Stamford Hill Road, Durban, between 12:45 and 1300 hours. Mullah took Gangat to Saku's brother's shop in Victoria Street. After taking Gangat home, Saku learned that he had been tortured by the security branch. Gangat died in 2017. So the account below is Saku's recollection of what he told her. Gangat told Saku that 2 men from the security branch arrived at his hospital and asked him if he knew Hoosen. He answered in the affirmative, and he was instructed to follow them to a car. Gangat scribbled a note to one of the nurses at the hospital to say that he had been taken by the security branch. According to Sakur, Gangat was blindfolded in the car. While in the car, Gangat was asked about what he and Hoosen had been discussing over the phone the day before Hoosen was arrested. Gangat replied that they talked about the day's work schedule, but the security branch officers did not believe him. When they reached an unknown place, the security branch took him to an unknown room. In this room, the security branch asked Gangat if he was a communist and whether they were planning unrest in the country, and if Hoosen was trained to make bombs. Gangat told them they were not communists, but dentists, and that he and Hoosen never talked about bombs or communism. This upset the security branch members. Gangat was then taken to another room where he was subjected to forms of torture by being stripped naked, his head pushed repeatedly into a container of water, shocked with electrodes on his head, his hands and feet tied behind and hung upside down by his feet, and beaten and forced to say what he knew about Hoosen and about their plans, which lasted for more than an hour. Sakur testified that the security branch followed her husband everywhere following Hoosen's death. Sakur and Gangat realized that Gangat's phone at the hospital must have been bugged, and that is how the security branch knew that Gangat and Hoosen had been in contact. Their domestic workers were interrogated and threatened. The couple were followed to and from work, and Gangat's practice was repeatedly raided, which had an adverse effect on patients. They discovered that Gangat's hospital phone had been bugged by Johnny Swanepoel, a police reservist who had been planted at the hospital by the security branch. Sarah testified that her elder brother, Yusuf, was hanging up photographs of security branch police officials, Taylor and Dutoy, outside their family shop window with the caption which read, quote unquote, "Who killed Hoosen?" Police officers came to the shop to instruct him to remove the photographs, but he refused. Sarah also recalled that the police officers came to their home around midnight to search the house. She could not recall the date. They searched her mother's and Hoosen's rooms. They also tried to search Yusuf's room, but he refused to let them in. After Hoosen's death, Ismail said that the security branch started to follow the Haffejee family. In one instance, he recalled security branch vehicles parked opposite the family shop, and they watched who came in and who left. At the first inquest, the Haffejee family was represented by Dr. W. Cooper SC, Mr. S.A.K. Pittman, and Mr. I. Mohammed. The family's case was that Tutoy and Taylor used third-degree methods and deliberately inflicted injuries on Hussein while in interrogation. Since the security branch believed that Hussein had been trained in urban terrorism and belonged to a subversive movement, the security branch had a powerful motive to apply excessive and extensive interrogation methods. Accordingly, the core focus of the family's representatives was on the injuries sustained by Hussein. Counsel for the family challenged the versions of Tutoy and Taylor that Hussein sustained these horrific injuries by resisting arrest. This was because Tutoy and Taylor were unable to explain, with reference to specific incidents, how each injury was sustained. Dr. Lawrence, a surgeon, asserted that the nature, extent, and distribution of the injuries indicated that they could not have been sustained in the manner described by the security branch members. Lastly, the family argued that it was these deliberate assaults that ultimately led to the death of Hussein. However, Dr. Cooper quite inexplicably agreed with the magistrate that he could not ask for a finding that the death of Hussein was brought about by any act or omission as contemplated in the Inquest Act. It is submitted in this inquest that there was no factual or legal basis for Dr. Cooper to have made such a concession. Dr. Cooper urged the court not to make a finding of suicide because the Inquest Act did not require a court to go that far in making a finding. Well, astonishingly, Magistrate Blunden agreed and made the finding that nobody was responsible for Hussein's death, even though he had died in unnatural circumstances, and Magistrate Blunden had apparently already concluded that Hussein had committed suicide. Magistrate Blunden found that the evidence of Tutoy and Taylor coincided in all material respects. It was submitted by the family's counsel. It is submitted by the family's counsel that this is hardly surprising, given that the two had colluded in the cover-up. Their evidence will be considered together for the purposes of the first inquest. Magistrate Blunden accepted the following evidence of Tutoy and Taylor without question. A, the security branch had been interested in the activities of Hussein since about April 1977. B, during this time, entry was gained into Hussein's flat and documents removed, photocopied, and replaced. These documents were highly incriminating in that they showed Hussein engaging in subversive activities. It was decided, C, it was decided that Hussein be arrested to question him and perhaps charge him. According to Taylor, at around 6:30 on Tuesday, 2 August 1977, Taylor, Tutoy, McPherson, Lieutenant Munsami, Adjunct Officer Naidu, and Kopal arrived in the vicinity of Hussein's flat. D, on driving away from his flat, Hussein was pursued by Taylor. Taylor signaled Hussein to pull over. Hussein failed to comply, which resulted in Taylor forcing him off the road by cutting in front of him. Since Hussein was believed to be a trained saboteur and it was thought he might be dangerous, it was prearranged between Tutoy and Taylor that Hussein's car would be immediately assessed for weapons. E, however, Hussein resisted arrest. Tutoy then came to Taylor's assistance and gripped Hussein from behind, bumped Hussein up against his car, and held him in that position until Taylor established that he was unarmed. Hussein refused to accompany them to the police station. Tutoy and Taylor placed Hussein into his car by force, but he put up a quote-unquote spirited resistance. F. Tutoy claimed that he did not want to use excessive force because he did not want to injure Hoosen unnecessarily. As a result, he struggled to get Hoosen into his own vehicle. Eventually, Taylor pinned Hoosen down on the seat while Tutoy pulled him into the car. G. Hoosen was then taken to Brighton Beach Police Station, where he was interrogated for various periods during the day until 2000 hours, when Hoosen was taken to the North Pier. H. According to Taylor, Hoosen was first questioned from 9:20 to 11 in the morning. I. According to both Taylor and Tutoy, from 11 to 1300 hours, Hoosen was taken to various unidentified locations in the Greater Durban area by Taylor, Tutoy, McPherson, and Lieutenant Munsami. J. According to Taylor, between 1300 hours and 30 and 14 hours 15, a lunch break was taken. Hoosen was in a room with Taylor, Tutoy, McPherson, and Munsami. K. Taylor states that Hoosen was interrogated between 14 hours 15 and 16 hours 15. Hoosen then had a break between 16 hours 15 and 16 hours 30 before interrogation continued. Between 16 hours 30 and 18 hours 20, Hoosen was interrogated about his reading habits. L. Tutoy's version was that the interrogation continued from 14 hours 15 for 4 hours until 1800 hours. M. According to Taylor, Hoosen took a break between 18 hours 20 to 18 hours 40 when he had a sandwich and a cool drink. The interrogation resumed on the question of certain literature. At around 2000 hours, Hoosen eventually told them that the literature was dumped in the sea. And at the North Pier, Hoosen was instructed to point out where the supposed subversive literature was. He did the pointing, but nothing was found. Hoosen was thereafter ordered to get back into the vehicle, but refused. For the second time that day, force had to be used. Another physical struggle ensued, and he was forcefully taken back to Brighton Beach Police Station at around 21 hours 20, where the interrogation continued. O. Tutoy and Taylor were adamant that Hoosen's injuries were sustained during the periods in which he resisted arrest. P. At around 2300 hours, photocopies of the documents seized from Hoosen's flat were shown to him. Up to that point, and according to Taylor, Hoosen was unaware that the security branch had these documents. This caused Hoosen to become visibly shaken. Q. The documents were photocopies of the originals and included a handwritten document for which the magistrate accepted the evidence of the handwriting expert, Warrant Officer Pretorius, to be the writing of Hoosen. Allegedly, the documents proposed a general insurrection and detailed instruction of how death and destruction may be used to achieve such insurrection. The handwritten document contained details of how to make a wide variety of explosives and incendiary devices, the ingredients required, and diagrams for the manufacturing This caused Hoosen to become extremely uncooperative. Shortly after midnight, when it became apparent that no progress was being made, the interrogation was suspended until the next morning. As at the church office, Hoosen was handed over to the uniformed members on duty, where the formalities were completed. He was then taken to cell number 2, where he was locked up for the night. T. Tutoy and Taylor were wholly unaware of any injuries sustained by Hoosen. He showed no signs of having been injured and made no complaint to the security branch or the uniformed members at the church office. They could not connect any injury to either of the two struggles. Both noticed that at various points in time, Hoosen's body encountered various parts of the car in question. According to both, Hoosen could have easily bumped his head on the radio console protruding between the two front seats while resisting arrest. In cross-examination, it was put to Dutoy and Taylor that they were bigger, heavier, and stronger men than Hoosen. Both explained that subduing Hoosen would not have been an issue due to their superior physical advantages. Hoosen could have easily been subdued and placed in the car. However, they claimed that their objective was to use as little force as possible to avoid causing unnecessary injury. Dutoy claimed that it was extraordinarily difficult to thrust even a small man into a vehicle if such person was declining to cooperate. Nordier was a 19-year-old uniformed Brent constable in the charge office at Brighton Beach Police Station. His evidence was that no one had access to Hoosen from the time he was locked in cell number 2, except Meyer himself and Madlala. He said he had sole custody of the cell keys. Every hour on the hour, he and Madlala carried out a cell inspection. At 3 in the morning, Hoosen did not exhibit any signs of injury and made no complaints while lying on the cell mat. Hoosen was awake and did not sleep that evening. At around 4 in the morning, Nordier found Hoosen dead, suspended by his trousers. Senior officers, including Dutoy, were called in, and at 7 in the morning, Gordon arrived at the station. It should be noted that the other two charge office policemen, Madlala and Meyer, were not called to testify in the first inquest. They provided statements which were labeled as Exhibit X and Z, but these form part of the missing exhibits from that first inquest. According to Gordon, the probable time of death was between 3 and 4 in the morning. Gordon was of the view that Hoosen's injuries were sustained within a period of 4 to 12 hours before his death. Clarkman and Lawrence, the experts for the family, differed with Gordon and concluded that the lesions from the back and the right iliac crest were probably inflicted between 8 and 24 hours before death, and at least one other injury would have occurred before 4 and 6 hours before death. In addition to the superficial injuries, a dissection made by Gordon revealed A, varying zones of engorgement in the intestines and an area of extravasation of blood in the substance of the mesentery. B, extensive extravasation of blood in the subcutaneous tissue and muscles of the scalp. C, there were no fractures to the skull, and his thick mop of hair may have cushioned any blow to the head. In examining the ligature mark, Gordon excluded the possibility of post-mortem hanging. This conclusion was disputed by NATO, as will be discussed below. The knots in the trousers were examined by Needling. The consensus between Needling and Gordon was that there was nothing out of the ordinary about the knots, and they were the kind of knots a layperson might have tied. Needling performed a simulation, which was recorded on video and shown to the court, which persuaded the magistrate that Hoosen would have been capable of committing suicide in the way postulated by Needling. The video has since disappeared. The conclusions of Needling and Gordon are disputed by an expert witness and mechanical engineer Devash Moodley, as will be discussed below. Gordon concluded that Hussein's death was consistent with hanging and that the injuries, other than those attributable to the ligature, in no way contributed to Hussein's death. Gordon suggested that the injuries were minor, except the injury to the scalp and mesentery. He said the bruises to the sternum, ribs, and loins could be described as quote-unquote significant. Gordon refused to comment on the probabilities of Hussein's injuries being sustained as illustrated by Taylor and Tutoy. He was not prepared to comment on the mechanisms that caused the injuries, nor was he prepared to make a scientific assessment of the degree of force required to cause them. He claimed that since a layperson was in as good a position as a medically trained person to make the assessments of this kind, he would decline to give a view. He was, however, prepared to concede that blunt force could take the form of a blow with fists or a kick, but was not prepared to concede that the police version was far-fetched. He ruled out the possibility that the injuries could have been self-inflicted in the cells during the process of hanging. Lorenz, the expert surgeon for the family, provided the following evidence. The extravasation of blood into the subcutaneous tissues of the scalp required a direct blow of some significance. Such a blow could not have gone unnoticed, and one might reasonably have expected Hussein to have been dazed or concussed. Though speculative, he commented that the mechanics of injury to the scalp would have been due to a direct blow to the head of Hussein. The same applied to the injury to the mesentery. This sort of injury would have caused a person to be winded, and if so, it would have been noticeable. He agreed that the abraded bruises were not in themselves serious. However, what was significant was that there were many of them, and their distribution was striking. Lorenz was of the view that it was unlikely that Hussein could have sustained that many injuries during two scuffles. Going to the magistrate's finding. In his finding, dated 15 March 1978, Magistrate Blunden found that A, the evidence of Taylor and Tutoy was found to be reasonably true. B, there was no dispute about the events that followed after the handing over of Hussein by the security branch to the uniform branch in the church office. C, there was no suggestion by anyone that the death of Hussein can in any way be attributed to a homicidal act on the part of any person or persons. D, no one seemed to have had a motive to kill Hussein. E, Hussein would have been worth more alive than dead to the security branch. F, Hussein, on the other hand, and I quote, undoubtedly had a strong motive to do away with himself. No conclusion is reasonably possible other than that he did just that. That is, he committed suicide by hanging himself. Close quotation. According to Magistrate Blunden, the mechanics of hanging did not explain the injuries. However, the consensus of all the medical experts were that the injuries occurred before Hussein was handed over to the church office staff. At least some of the injuries were in all probability sustained while in the custody of the security branch. However, the magistrate rejected the view that the injuries were deliberate and considered such an assertion as mere speculation. Breathtakingly, he held that even if there were eyewitnesses to a deliberate infliction of injuries, such evidence would be entirely irrelevant, as such injuries were not related to the death of Hussein. Accordingly, Magistrate Blunden found that Hussein died by hanging, and his death was not brought about by any act or omission involving any person. In a final act of absurdity, he concluded that Inquest Act does not require a formal finding of suicide and made no such finding. Apartheid system, the apartheid system introduced a structural bias in the criminal justice system, particularly in the magistrates' courts, in favor of the apartheid agenda. Magistrates were appointed predominantly from the public service rather than the legal fraternity. They were appointed by the Minister of Justice in terms of Section 9 of the Magistrates' Courts Act. The majority were former prosecutors who often interacted with security branch members. Magistrates and district surgeons were tasked with ensuring the well-being of detainees. This placed magistrates at the quote-unquote coalface of the apartheid government's engagement with political prisoners. The TRC had the following to say about the magistracy as a whole. And I quote, "The Commission deplores and regrets the almost complete failure of the magistracy to respond to the Commission's invitation, the more so considering the previous lack of formal independence of magistrates and the dismal record as servants of the apartheid state in the past," close quotation. The TRC also concluded that collusion had taken place between police and prosecutors who collaborated with police to undermine the cases of victims and or their families. In an affidavit provided to the reopened inquest into the death of Agat, the late Mr. Bezos SC referred to the state of the magistrates in South Africa under apartheid. Mr. Bezos pointed out that most apartheid-era magistrates had no real desire to reach the truth. It appeared that some of these magistrates saw it as their duty to protect organs of the state, such as the police. Magistrates tended not to interrogate police versions that vigorously. By way of example, magistrates invariably never asked police the most obvious question: why should a detainee commit suicide when he had the option of remaining silent under interrogation? Mr. Bezos noted that apartheid-era inquest courts tended to minimize evidence of the ill treatment of detainees. Official police versions were often contradicted by forensic pathologists who examined the bodies of detainees. Magistrates typically ignored such expert evidence and uncritically accepted the versions of police witnesses. Improbable testimony of police witnesses was invariably rubber-stamped by inquest magistrates. Police versions that deceased detainees were treated with care and consideration were readily accepted by the courts, notwithstanding evidence of pre-death. Mosla J, in the reopened inquest into the death of Ahmed Timol, held that, and I quote, "It will be remiss of this court not to address an issue on which Bezos's evidence put a spotlight. This is the impropriety role played by some in the magistracy, prosecuting authorities, and medical experts in the past inquest proceedings. Bezos's evidence reveals the role of some of these public officials in being complicit in exonerating members of the security branch from the crimes they committed. The 1972 inquest into the death of Timol is one such example. From the outset, it had to take a court order to allow Timol's family and their lawyers access to case documents before the inquest commenced. The evidence of the 1972 inquest further demonstrates how the prosecution made no effort to obtain evidence other than that of the police and the magistrate attempting to explain away the ante-mortem injuries. without any shred of evidence supporting his statement about a brawl, close quote. The first inquest finding of the magistrate makes for pitiful reading. He accepted the police version without question. He did not even raise the slightest concern or apprehension about its improbabilities. Examples of Blanden's disinterest in the truth was his acceptance of the claims by Taylor and Tutoy that Hoosen was violent in nature, in that he strenuously resisted arrest and had to be forced into the vehicle on the morning of 2 August 1977, and that he again resisted being placed back into the vehicle following the so-called pointing out at North Pier on the beach at 2000 hours. The evidence of Taylor and Tutoy is not believable. The evidence shows that Hoosen had an unusually small physique for a 26-year-old weighing only 49 kilograms with a height of 1.75 meters. He had a body mass index of only 16 when it should have been between 18.5 and 24.9. According to the evidence of Naidu, the average weight of a 14-year-old boy would have been 49 kilograms, rendering Hoosen remarkably underweight. In contrast, Tutoy and Taylor would not have been out of place in the front or second row of a rugby scrum. Tutoy weighed 109 kilograms and his height was 1.98 meters, giving him a BMI of approximately 27.8. Taylor weighed in at 82 kilograms with a height of over 1.75 meters, giving him a BMI of 26.8. Indeed, Tutoy admitted that he had been a rugby player, and Taylor considered that, quote-unquote, played rugby at the time. There were at least 6 police officers present at the arrest, and at least 4 were supposedly present at the alleged pointing out at the North Pier. The claim that Hoosen, a tiny person, would have taken on multiple police officers, especially those the size of Tutoy and Taylor on 2 occasions, stretches belief to a breaking point. Indeed, the evidence of Gopal is that the so-called pointing out at North Pier in the harbor never took place. It was merely a story invented to try and explain away injuries all over Hoosen's body. In fact, the fabrication went to the length of producing images of the sites where these alleged scuffles took place and was produced as evidence in the first inquest. The fabrication, however, is easily understood. The security branch had to come up with an explanation for the nearly 50 injuries inflicted on Hoosen. Gopal's evidence was that Tutoy and Taylor concocted their stories, and they instructed him to make sure his story aligned with theirs. Gopal was told that if he were to testify, he would have to say whatever he was told to say. In so doing, the security branch was accommodated by a pliant magistrate who was willing to avert his gaze from logic and the facts. Magistrate Blunden accepted the versions of Taylor, Tutoy, Notier, and Madlala that Hoosen was injury-free and made no complaint to them, when in fact the injuries reflected in the post-mortem report would have seriously incapacitated him and caused him much pain, which would have been evident to all, as per the evidence of Lorenz. Even Gordon's evidence, which Blunden accepted, considered that the blunt force injury to Hoosen's scalp and mesentery and the bruises to his sternum, ribs, and loins were quote-unquote significant. Blunden, in his rush to exonerate the police, saw no contradiction in accepting these mutually destructive versions. If Blunden had been engaged in a serious search for the truth, he would have found the evidence of Tutoy, Taylor, Nodier, and Madlala to be highly improbable, raising serious questions as to what they were hiding. Instead, Blunden casually found that nobody had a motive to kill Hoosen, completely ignoring the impact of the 50-odd injuries on him and the serious implications for the police in trying to explain how these occurred, particularly since it is likely that by the end of Hoosen's ordeal, he was most likely incapacitated, unconscious, or dead. Blunden studiously avoided exploring the possibility that Hoosen succumbed under torture. Given the medical evidence, Blunden was forced to accept that there, and open quote, seems little doubt that at least some of the injuries found on the body were in all probability sustained by him while he was in police custody, while he was in the custody of the security police concerned. That is Captain Tutoy and Lieutenant Taylor, close quotation. However, notwithstanding this concession, Blunden concludes that any suggestion that Tutoy and Taylor were responsible for such injuries, quote unquote, is completely unsupported by any evidence and is in fact mere speculation. This jaw-dropping conclusion was reached based on their denials under oath that they corroborated each other, that any such injuries occurred in the two subduing incidents, and that the two were, open quote, unshaken by cross-examination, which was long and searching, close quote. Denials by security branch officers under oath were good enough for Blunden. It is quite apparent that Taylor and Tutoy were unshaken in cross-examination because they always knew they had nothing to fear from the inquest proceedings. As stated above, apartheid-era inquests involving the security branch were charades designed for the purpose of covering up the truth. Blunden went so far as to claim that even if there was, and I open quote, direct eyewitness evidence of a deliberate infliction of injuries, close unquote, by the police, this would be, open quote, entirely irrelevant to this inquest, close quote, since these acts are, open quote, collateral or completely unconnected with the main issue, close quote, namely the death. Blunden offered no explanation for this crass conclusion. He suggests that the very context in which the death occurred is irrelevant to an investigation into how the death occurred. This is particularly startling, given how important the context is to cases of alleged suicide in police custody. Blunden's willful avoidance of the search for the truth is abundantly evident from his clumsy attempt to compartmentalize the story and prevent the making of obvious connections between the chain of events. There was not the slightest attempt to explore the impact of the injuries on the physical and mental being of the deceased, and if it was suicide, whether it was an induced suicide, given the brutality visited upon Hoosen. Not a single question was raised about what security branch officers were willing to do to protect themselves from the inevitable scrutiny that would follow. Blunden concludes his woeful finding by claiming that after, quote-unquote, careful consideration, the Inquest Act does not require him to make a finding of suicide, even if the death was a suicide. In his final cop-out, he finds that Hoosen, quote-unquote, died by hanging, which, open quote, was not brought about by any act or omission amounting to an offense on the part of any person, close quotation. Aside from the obvious misreading of the Inquest Act, it is mind-boggling as to why Blunden could not bring himself to put up a reason behind the hanging when he already concluded that the hanging was self-inflicted. This is especially so when Blunden suggests earlier in his judgment that Hoosen had, open quote, a strong motive to do away with himself, close quotation. This apparent motive is because Hoosen was supposedly exposed after the documents found in his flat were presented to him during interrogation. These documents, which have since disappeared, allegedly included various unidentified handwritten documents, pamphlets, and documents on explosives. I'll deal with bias. Impartiality and bias are defined in S. versus Lagrange and others as follows, and I quote, "Impartiality can be described, perhaps somewhat inexactly, as a state of mind in which the adjudicator is disinterested in the outcome and is open to persuasion by the evidence and submissions. In contrast, bias denotes a state of mind that is in some way predisposed to a particular result, or that is closed with regard to particular issues. Bias, in the sense of judicial bias, has been said to mean a departure from the standard of even-handed justice which the law requires from those who occupy judicial office." Close quotation. In S. versus Dube and others, it was held, and I quote, "What the law requires not only that a judicial officer must conduct the trial open-mindedly, impartially, and fairly, but that such conduct must be manifest to all those who are concerned in the trial and its outcome, especially the accused." Close quotation. It seems clear to me that the first inquest into Hoosen's death was riddled with examples of bias on the part of the presiding magistrate. Blunden misdirected himself in accepting, without question, the say-so of the police, paid no heed to the cause, nature, and extent of the injuries of Hoosen, refused to apply his mind to the evidence of Lawrence, and finding that the injuries, even though they occurred while in custody, were irrelevant and not concerned to Hoosen's death. It appears to me that Blunden conducted himself in a manner that was predisposed to a particular result, namely the exoneration of the police from all wrongdoing. He refused to apply his mind and went out of his way to give the police version a veneer of respectability. It was manifest to any casual observer of the first inquest that the magistrate paid little or no regard to the standard of even-handed justice. His manifest bias was plain to see. In reopened inquest into the death of Ahmed Esop Timol, the court aptly stated that an inquest is an inquisitorial process, and quoted from decision of Timol versus the Magistrate of Johannesburg thus, and I quote, "Nevertheless, the inquest must be so thorough that the public and interested parties are satisfied that there has been a full and fair investigation into the circumstances of death." Close quotation. The first inquest into the death of Hoosen did not come remotely close to resembling a full and fair investigation. It is my considered view that Blunden conducted a substandard inquiry aimed at rubber-stamping the police version. He conducted himself disgracefully. One also saw no evidence of the prosecutor pursuing anything resembling a thorough investigation. It is hardly surprising that the Haffejee family and the wider community regarded the first inquest as little more than an extension of the police cover-up dressed up with judicial gloss. On this ground alone, the finding of the first inquest warrants overturning. It is apposite to outline the history and evidence of abuse and torture meted out by the security branch to detainees. Such history is necessary to establish a modus operandi they employ during their illegal operations. The evidence reflects that the conduct of Hoosen's detention bears absolutely no resemblance to the version placed by the security branch before the first inquest court. Bezos, in his affidavit before the reopened Arcade inquest, described how apartheid-era detainees routinely complained of torture and the police often being sued in the civil courts for torture and damages which were awarded against them. These include the widow of Imam Abdullah Harun, who sued the state for $22,000 in respect of her husband's death and received an ex gratia payment of $5,000. The mother and sons of Steve Biko similarly sued the state and were paid an amount of 65,000 rand. According to Gopal, the security branch officers were considered the quote-unquote bosses above bosses. They were not constrained by the ordinary 48-hour periods of detention and relied on the draconian powers of Sections 6 and 10 of the Terrorism Act. They could use all the time they needed to extract information from anti-apartheid activists. There was a certain culture within the security branch that was oppressive and instilled fear into the hearts of its members, particularly members of color. There was a general culture of white superiority. If a police officer of color did not toe the line, which included covering up, the security branch would fabricate stories against them. Commanding officers had full knowledge of the use of the third degree, that is the use of excessive force, and approved of it. And if junior members of the uniform branch were told by the security branch to do anything, they would simply do it. For example, if they were told not to do any paperwork, they would not do it. Maya considered that the security branch enjoyed a superior status within the police. The security branch was able to order the uniform branch to do tasks, and the uniform branch was in a subservient position. Maya believed that the security branch were law unto themselves. And I quote him, "The security branch enjoyed amnesty to do anything. You never heard of the security branch getting into trouble. They assaulted, detained, and kidnapped people as they wanted," close quotation. Maya also conceded under cross-examination that uniform branch members were afraid of the security branch because they were so powerful and had their ways of keeping everyone in line. Squealing on the security branch meant serious repercussions, such as demotion and even physical harm. Nadir described the security branch as, and I quote, "this secret guardian division of the force, supposedly looking after the people of South Africa's best interests," close quotation. He claimed not to have knowledge of what the security branch was doing during apartheid, but was aware that they detained people regarded as a threat to national security. He heard rumors that detainees were assaulted and tortured, but claimed, not convincingly, that he did not know this for sure. The reopened inquest into the death of Ahmed Tumol confirmed the practice that torture would be deliberately inflicted in such a manner that its effect would leave little or no evidence. The ill treatment of detainees is often visualized or expressed in the form of physical assault, that is, beatings of detainees. It is indeed so the physical assault, apart from being a common method to hurt and bring fear into a detainee, it is also easier to prove by reference to scars from injuries or evidence of medical treatment. However, there are other less mentioned forms of torture which leave no evidence and are difficult to prove, such as sleep deprivation, long hours of standing, and interrogation, as well as electrocution, close quote. In the case of Hoosen, the interrogation team observed no such niceties, thus leaving some 50 visible marks on Hoosen's body. This forced them to fabricate a crude cover-up story involving the two scuffles. The inquest court in Timor found that torture extended beyond physical violence to include a broader, quote-unquote, rubric of torture that encompassed all forms of abuse visited on detainees. It stated, and I quote, "This court is of the view that on the basis of the evidence received, it would be misleading to refer only to physical assault as the ill treatment of detainees. Detainees were subjected to beatings at various levels of brutality, with the least being only slapped once across the face. It nevertheless remains an assault, but are not comparable to those who were hit with solid objects, punched and kicked. It would be more accurate to deal with the subject of ill treatment or abuse of detainees under the rubric of torture, as it includes all forms of abuse visited on the detainees," close quote. Malta J found that detention under Terrorism Act was at times an effective death sentence, and I quote, "The evidence in these and other inquests demonstrate this drastic legislation became a tool in the hands of some members of the security branch, not only to torture but also to kill detainees with impunity," close quotation. The court's finding in Timor was epitomized by its rejection of the evidence of the security branch officers in the following terms, and I quote, "The evidence of assault and other forms of torture of detainees presented in the 2017 reopened inquest is so overwhelming that the denial and lack of knowledge thereof by the three former security branch police officers who testified is disingenuous. Further, the fact that each one of them testified during the 2017 reopened inquest that they knew nothing about assault apart from what they read in the media is a demonstration that they were regurgitating a standard response similarly prescribed to all members of the security branch. Else, Sanz and Rodriguez's conduct calls for censure. Their conduct must be investigated further with a view to raise appropriate charges," close quotation. These findings are consistent with the conclusions of the TRC report, which found that torture and the killing of detainees by the security branch was quote-unquote strong possibility. It concluded thus, and I quote, "The Commission has taken into consideration the evidence of victims of torture, which could well have, especially those cases in which similar forms of torture did lead to death. A number of cases were recorded of detainees having their heads bashed against the wall and of detainees who are suspended by their feet outside windows of buildings of several stories, raising the strong possibility that at least some of those detainees who allegedly committed suicide by jumping out of the window were either accidentally dropped down or thrown," close quotation. Apartheid state-sanctioned extrajudicial killings and rampant criminality by state security organs were the order of the day during the 1970s and 1980s. At the TRC, a former commander of the security branch, Johannes Velde van der Werve, confirmed this, and I quote, all the powers were to avoid the ANC/SACP achieve their revolutionary aims, and often with the approval of the previous government, we had to move outside the boundaries of the law. That inevitably led to the fact that the capabilities of the SAP, especially the security forces, included illegal acts. People were involved in a life and death struggle in an attempt to counter this onslaught by the SACP/ANC, and they consequently had a virtually impossible task to judge between legal and illegal action, close quote. The TRC found that during this period, the state committed a host of gross violations of human rights in South Africa. These included, amongst other violations, extrajudicial killings and torture. The Police Act mandated the South African police with inter alia the preservation of internal safety. The security branch was charged with spearheading this function. The security branch was the effective intelligence wing of the former SAP, falling directly under the Commissioner of Police. It operated in a separate and parallel structure of the uniform and detective branches. The security branch targeted any person or organization which opposed the government. Its activities included the close monitoring of the affairs and movements of such persons, the detention of thousands, and the torture of many. Christopher Reginald Clifford Marion is a private investigator who investigated the Haffejee's case. He is a retired SAPS brigadier and a former provincial head of detective services in KwaZulu-Natal with 40 years policing experience. He is employed by the Foundation for Human Rights to investigate serious apartheid-era crimes as part of its unfinished business of the Truth and Reconciliation Commission project. Marion was of the view that the probabilities pointed to the possibility that Hussein died under interrogation. Alternatively, Hussein was in such a debilitated state that he was murdered to protect the security branch from scrutiny. Marion is of the opinion that the cover-up and staging of suicide was done either to conceal the abuse and brutal torture of Hussein or to mask the fact that he died during interrogation. The police version before the first inquest was accordingly Concon Beach Police Station between 2 and 3 August 1977. More about his evidence later. In the Timol inquest, the court found that the security branch routinely invented cover-up stories to quote-unquote shield police from blame and cover up crimes committed by members of the security branch. And I quote, "In order to implement this cover-up strategy, the assistance of some selected members of the prosecuting authority, medical profession, and magistracy were roped in to be part of the sham. Officials from these professions were carefully selected to support a cover-up version in the case of any delictual proceedings," close quotation. The first Hussein inquest was no exception. The evidence before this court clearly demonstrates that the apartheid state concocted an elaborate scheme to cover up the circumstances surrounding Hussein's death, which will be dealt with in detail below. Gopal testified that he was asked to cover up and stick to a specific story. It was also his evidence that Dutoy and Taylor lied under oath and that Hussein did not get injured while being placed into various vehicles. In the reopened inquest, substantial evidence of torture at Fisher Street and other venues in Durban was presented by several former detainees who were interrogated and tortured during the 1970s and 1980s. The summary of similar fact evidence follows hereunder. Starting with Kambadelson Subramani Coastal Governor. Coastal was a member of the NIC and a former police officer with the rank of major in crime intelligence. He was arrested in the second week of September 1977 under Section 6 of the Terrorism Act. Coastal was taken to the security branch headquarters in Fisher Street for interrogation. According to Coastal, the officers present included Taylor Kopal, V.R. Naidu, and Major Benjamin. Coastal says that he was hit a few times, ordered to take his clothes off, kicked by 4 or 5 people at a time, fell on the floor several times. Ball pens were put between his fingers and squeezed his fingers on both hands. Was made to sit with hands outstretched on an imaginary chair and was kicked under his arms. If he fell, he would be kicked until he got back on his feet. He also recalled having his private parts squeezed. Coastal recalled one evening having some form of electrical device applied to his genitals and being shocked. He said he was held by his hair and his head pushed into a toilet at least twice by Taylor. According to Kopal, Taylor meted out the same treatment to Hussein. While he was assaulted, one of the Indian officers in the interrogation said to him that the white officers will kill him like they killed Hussein. Coastal could not recall whether this was Kopal, V.R. Naidu, or Major Benjamin. Coastal testified that the Indian officers did assault him, but their assaults were milder than that of the white officers. During the evening of the first day, Coastal was again stripped naked and further assaulted. The assaults ended sometime after 2100 hours. Coastal was then taken to Mayville police station for detention. He testified that he could not walk and had to be carried out of the car. The next morning, he was taken back to Fisher Street where he was stripped again and heavily assaulted. His abuse included forced squats. The same security branch officers were present. He said the officers used slaps on his face as opposed to punches to avoid visible injuries. His torture stopped at around 1500 hours when a senior officer, Kutsia, walked in. Mohammed Timol. Mr. Mohammed Timol is a former ANC struggle activist and brother of the late Ahmed Timol, who was murdered by the security branch while in detention at John Foster Square in 1971. He was a former South African diplomat in London and Brussels. Timol was arrested in Durban by 6 members of the security branch on 25 October 1971 and taken to Fisher Street security branch offices. He was interrogated at Fisher Street offices from 11 to about 2300 hours. He was never left alone. The officers made him to stand on a brick in the office and was made to hold up 2 telephone directories for hours. He was repeatedly beaten up whenever he became unsteady or lowered his directories. He received blows to his stomach, legs, and body. Thereafter, he was taken to Berea police station, where he was held up in a lock-up cell. Timol was taken back to Fisher Street the next morning for more interrogation and was further assaulted. He was made to sit on an imaginary chair, which the police called, quote-unquote, golden chair. He was beaten up whenever he relaxed. He was then asked to do the golden chair until he gave in and told the security branch about his political activities in the United Kingdom and his contact with Dr. Yusuf Dadoo. They continued to interrogate and torture him until 2300 hours that evening. The interrogation continued from Monday, 25 October to Wednesday evening, 27 October, till about 1800 hours each evening. He was not punched or kicked in the face. He said this was because the security branch were trying to avoid any visible injuries. Raymond Sorrel Satner. Professor Raymond Sorrel Satner is an emeritus professor at the University of South Africa. He was involved in the liberation struggle in the 1970s and was a lecturer at the University of Natal, Durban. In June 1975, he was detained and tortured by the security branch. He was arrested after spending hours distributing illegal pamphlets in Durban and Pietermaritzburg and was taken to Fisher Street. He experienced 2 events of interrogation and torture by the security branch. The first interrogation happened with the police officers questioning him in teams of 2 or 3 at a time. The assault started after he said he would not answer further questions. Colonel S. Steenkamp, the head of the security branch in Durban, came in the interrogation room and shouted, quote unquote, "This is serious, man." And he twisted Sadna's nose and then left. Sadna believed that the twisting of his nose was a signal to, quote unquote, change approach. Shortly after Steenkamp left, Andy Taylor, not Jimmy Taylor, Andy Taylor, entered the room. Sadna described Andy Taylor as a very tall man who was wearing a white butcher's apron and carrying handcuffs. Andy Taylor took off Sadna's glasses and put on the handcuffs and said that, quote unquote, this was serious. Sadna was ordered to strip off all his clothes and instructed to lie down. They held him at various points of his body, by legs and shoulders. A cloth was put around his mouth. Electric wires were attached to his penis. Captain Dreyer pulled out some of Sadna's pubic hairs and hair from his head, beard, and legs. The security branch officers began administering electric shocks. They blocked his shouting with a gag and made obscene remarks such as, open quote, I want to see him come now, close quote. According to Sadna, the officers were aware of the danger of electric shocks because he heard them say, this is bad for your heart, you know. He was also subjected to anti-Semitic slurs. The torture continued until 7 or 8 the next morning. At around 2000 hours, Sadna was taken to Durban North Police Station. On his return to Fisher Street the next morning, he was taken to a room on the 4th floor with 2 large floodlights on a table and handcuffs on the floor. He was asked questions and made to face the lights while sitting against the wall. He was forced to sit on the invisible chair. His arms were stretched and he had to balance what they called, quote unquote, his Bibles, that is, books on Marx and Lenin, on each arm. Drawing pins were placed on the floor to prevent him from falling. When he dropped the books or fell on the floor, the books would be picked up and additional volumes were forced on him. Sadna experienced further modes of torture, which included stamping on his toes, kicking his shins, threats that he would be fucked up properly, that they would put up kafirs onto him, that he was fucking Jew, a threat to place a rat under a pot on his stomach, and other degrading treatment. Yunus Sheikh. I will pause there to be appropriate to take a lunch break. We'll proceed at 2 o'clock. Court is adjourned.
All right, please.
proceed. Eunice Sheikh. Sheikh is a non-practicing attorney and an executive director of Hoshkin Consolidated Investments Ltd. Between the late 1970s and early 1900s, Sheikh was active in the ANC underground and held leadership positions in the trade union movement. He was detained by the security branch for various periods during 1980 and between 1985 and 1986. In his evidence, Sheikh distinguished between two forms of detention: interrogatory and preventative. Interrogatory detention was used primarily to extract information from a detainee, while preventative detention was to stop an activist from mobilizing people and engaging in activities detrimental to the apartheid state. It was aimed at extricating an activist from society. While Sheikh experienced both forms of detention, his evidence focused on interrogatory detention. Sheikh highlighted the following significant features of security detention. A, security detention allowed for a detainee to be held in solitary confinement without any access to an attorney, family, friends, or anyone else other than state officials, such as police officers, a magistrate, or the district surgeon. B, the period of detention was unlimited and release was at the discretion of the investigating officer. The jurisdiction of the courts was excluded. C, a detainee was generally treated as an enemy of the state and suffered intense animosity and antipathy by the police, as well as from magistrates and district surgeons. If you were a member of the ANC or SACP, you were subjected to intense hatred and vilification. D, information was often extracted from a detainee by means of torture and wanton acts of cruelty that resulted in a detainee suffering trauma, severe physical injuries, and sometimes death. E, typically the security branch claimed that the cause of the trauma, physical injuries, or death were self-inflicted. This necessitated collusion between members of the security branch and at times other members of the erstwhile SAP. Sheikh was detained at Brighton Beach police station for 14 days in 1980 and interrogated at Fisher Street before being held for 6 months preventative detention at Modderfontein prison. He was not seriously mistreated during these periods in detention. He recalled the hourly inspections at the police cells at Brighton Beach police station. Sheikh was detained at C.R. Swart Square police station on 2 separate occasions under Section 29 of the Internal Security Act. The first was from 3 to 19 July 1985, and the second was from 3 August 1985 to the following year. He was ordered to strip naked. A white Hessian hood was placed over his head and the interrogation began. He was ordered to strip naked in order to prevent any evidence of blood or other fluids staining his clothes. The assault began with punches, knees and elbows to various parts of his body, his head, back, gut, and solar plex. He could not see who was assaulting him because he was hooded. A Sergeant Fisache pinned him down to the table and gripped his head and hands. His hands were bound by a rope and a bicycle tube-like substance. After a while, and after no information was given, there was a dramatic change in the method of torture. He had to get dressed and was led to another room where he again had to strip naked. He was hauled onto a table and forced to kneel, with his head and hands held against a tabletop. His hands were bound by rubber tubing, and his head was still covered by a damp Hessian hood. The soles of his feet and back were repeatedly struck with fists and what felt like a wooden club. While all this was happening, he was still being questioned. While in this position, an instrument was inserted into his anus and pushed into its far recesses, whilst at the same time he was struck on his lower back. These brutal assaults caused him to suffer excruciating pain. The more he was assaulted, the more he struggled to pull free from having his hands and head pressed against the table. The more he tried to pull free, the harder Fisagi tightened his grip on him. The wet Hessian bag held tightly on his head and face was causing him to suffocate. He testified that if that torture had gone on for a while longer, he believed that he would have died by asphyxiation. Sheikh described the experience of being hooded as quote-unquote dice with death because of the inability to breathe while being hooded and tortured. After a while, the assaults became random. During the torture, he lost consciousness several times and was revived. At times, he was dragged to the toilet and had water thrown on him. As he had soiled himself due to the ferocity of the torture, he was required to clean up. He suffered internal bleeding through his rectum, and lost hearing in one of his ears. Sheikh made the following observations from his experience in detention. A, typically, the station commander or duty officer would conduct inspections of the cells every hour. A police officer would be stationed in the courtyard of the cell block, and detainees would be under regular and frequent surveillance. B, notice would be taken if a detainee was in obvious distress. It was the responsibility of the station commander to attend to the needs of a detainee when held in his station. An appropriate entry was required to be made in the occurrence book. At the very least, a detainee would be observed at meal times, changing shifts, and scheduled cell inspections and patrols. C, a death in detention would result in the security branch orchestrating a cover-up of what happened. Police officers would typically deny that detainees were assaulted or badly treated and claim that injuries were self-inflicted. A culture of brotherhood existed amongst these security branch officers, which involved total secrecy and never implicating each other. D, district surgeons and magistrates would pay little attention to you and would ask you questions as formalities. There was no point in letting them know that you were assaulted because the reports of the magistrate and district surgeon went straight to the officers who were abusing you. The reports would not go to an independent party. E, security branch officers acted with total impunity. Since detainees were held incommunicado with no access to lawyers or doctors, they had a license to act as they wished with no fear of being held accountable. F, the uniform branch was subservient to the security branch. The security branch effectively had control over police stations where they operated and had total control over detainees held in police stations. If a security branch officer asked uniform branch members to do anything, they would do so without question. G, among those in the underground, it was not expected of a detainee to resist answering questions or to hold out indefinitely. Sheikh noted that one should hold out for about 3 days. The option of suicide or self-harm was never demanded or encouraged. Go back to evidence by Kangat. The evidence in relation to the abduction and torture of Kangat has been summarized above. Kangat died in 2017. The court relied on the evidence adduced by his wife, Sakor. This hearsay evidence was not challenged in terms of Section 31A of the Law of Evidence Amendment Act, and accordingly may be admitted in terms of Section 31C of that Act. The only direct evidence of Hoosen's abuse before this inquest comes from Gopal. He disclosed that the security branch conducted interrogations at Fisher Street, but also at private buildings around Durban that they used as safe houses. This particularly so when they needed to extract information quickly. According to Gopal, the typical forms of assault and torture used by the security branch included A, psychological abuse, B, sleep deprivation, C, continuous interrogation over several days, D, physical assault involving minor assault by slapping, and major assault such as quote-unquote panel beating and kicking. E, the helicopter method. The victim of torture is made to stand with his arms out, balanced on his toes, with a ruler on his head and crouched down. If the ruler falls, the detainee would be brutally kicked. F, electrocution. Wires were connected to a dynamo, clamped to the victim's body part, such as the nipple, genital, anus, kidney area, ear, or nostril. And G, wooden rulers were used to assault victims on their testicles. Gopal witnessed the following methods of torture being applied against Hoosen. A, stripped naked and left in his underpants, but later instructed to remove his underpants. The purpose of stripping was to not leave behind any stains on clothing and to humiliate him. B, slapped on the face with open palm slaps. C, kicked on the kidneys along his back and front, thighs and legs. D, hit and punched on the legs, ankles, private parts, buttocks, back of body, neck, arms and armpit. E, dragged by the back of the neck to the toilet with head pressed into the toilet bowl and made to drink toilet water. F, head smacked into a pillar. Gopal described the torture of Hoosen as, quote-unquote, a grotesque feature of a horrible nightmare that just unfolded before my very eyes, close quotation. In his evidence, he recalled that Hoosen could not bend because his entire body was sore, and he had to help him put his underpants on, was very bruised all over the body, but not bleeding, and could see marks all over his body, as he was quite a fair person. Gopal's description of torture is largely consistent with the findings of the expert medical witnesses. The postmortem findings of injuries and assessments done by Gordon and Lawrence et al. Were catalogued and evaluated herein earlier and will not be repeated. Further related and allied evidence is considered below. On 14 October 1977, a confidential request was made by Malcolm Smart of International Secretariat of Amnesty International's Africa Department to Professor Albrechtsen and members of the Amnesty International Danish medical team to assess the images and report of Biggs and to provide an expert opinion of the nature and causes of the marks on Hoosen's body. On 19 October 1977, the Danish medical team replied with the following findings. A, scattered on the trunk and the extremities are sequelae of blunt injuries of varying degrees. B, scattered on the back are well-defined irregular dark-colored marks which may be due to blows or prolonged pressure. C, similar skin injuries are located around the knees and elbows and in less degree around the ankle joints. They are due to some form of blunt violence. D, their nature and location might suggest that the victim had been restrained for some time. On 24 February 1978, the Danish medical team released a further report after assessing the report of Gordon and the supplementary report by Biggs. In this report, the team found that the bleedings in the scalp and the lesions on the body and the extremities were caused by heavy blunt violence while Hoosen was still alive. The bleeding around the mesenteries mentioned in the autopsy indicated blunt violence directed towards the lower abdomen. On 16 March 1978, following the judgment of Magistrate Blunden, Amnesty International released a statement critical of the judgment. The press statement challenged the finding that there was insufficient evidence to attribute Hoosen's death to any individual, since the injuries were sustained in the 4 to 12 hours before death, while in the custody of the police. Biggs testified on behalf of Haffejee family at the first inquest. As adumbrated earlier, he had, at the request of the Haffejee family, assessed Hoosen's body before he was buried. Biggs was examined in certain aspects of his report and on how his report found its way to the press. The salient points of his report in relation to evidence of abuse includes A, there were notable lesions, circular in shape, and some 6 millimeter in diameter on both sides of the ankles and on the right knee. B, the floor of the lesion was depressed below the level of the skin. C, on the left posterior aspect of the chest, there was a hand-sized discoloration, which may have indicated bruising. The face and neck were noted to be darker in color than the rest of the body, and there were subconjunctival hemorrhages in both eyes. Biggs produced a further report to explain the unusual and similar marks observed on the body. Biggs took photographs of the body. He said he had not seen such marks produced in any way. He noted that as an orthopedic surgeon, he had never seen such marks on a person injured in a collision. Biggs' evidence was not considered by Magistrate Blunden, since the counsel for the family stated that they would not be relying on it. Turning back to Naidu's evidence, already stated earlier, Naidu is an independent specialist forensic pathologist. He was instructed by the National Prosecuting Authority to study the medical evidence of the first inquest and provide an independent forensic medical opinion on the manner, circumstances, and cause of Hoosen's death. He compiled a report dated 23 February 2021 and testified at the reopened inquest. According to Naidu, the injuries inflicted on Hoosen's scalp, chest, and mesentery were caused by significant forces. He said these injuries would have been physically incapacitating, causing Hoosen to be in noticeable pain and in marked distress until his demise. If these injuries were inflicted in stages, then Hoosen's condition would have progressively worsened. Naidu's description of the most serious injuries is set out below. Head. The extravasation of blood or bleeding from ruptured blood vessels on the scalp can be described as deep scalp bruising. Such extensive bruising points to several physical impacts that rendered the bruising as a confluent, that is, meshed or blended into one set of hemorrhages. This meant that multiple blows were inflicted on Hoosen's head. Naidu could not exclude brain damage from the state of concussion. Such injuries would have induced unconsciousness or a lower state of consciousness or drowsiness as seen with a concussion. This would have disabled Hoosen, rendering him unable to walk or talk. Such injuries would not have been caused by the alleged scaffolds, which we now know were fabrications designed to mask the torture. Chest. The thoracic contusion or bruising is indicative of a heavy blow to the left lower front of the chest and would have been intensely painful. These blows would have resulted in cardiac concussion. Such blows would have left Hoosen winded, breathless, and doubled up in pain, not just quote-unquote winded. He would have been unable to sit or stand up or walk upright. It might have restricted abdominal movements and respiration due to mesenteric irritation. Naidu further noted that if there was no observable bleeding, death may have supervened very shortly after the abdominal impact, and it cannot be excluded that the death may have been caused by the abdominal impact themselves. General impact of injuries. According to Naidu, in light of Hoosen's injuries, it was not possible that the deceased was awake and normal when he was last visited in his cell at 300 hours, as claimed in the first inquest. An objective observer would have found a seriously injured person in noteworthy pain and distress if he was alive, if he was not unconscious or dead. Since these injuries were likely sustained under interrogation, Hoosen would not have been able to retain an upright or even a seated position. Since the injuries were between 4 and 12 hours old, the police officers at the church office would have been able to discern that Hoosen was in considerable pain and distress, even if his injuries were not immediately visible. Naidu believed that the bodily injuries would have been clearly noticeable when they were exposed to view, although the visible injuries do not necessarily indicate the full extent of physical harm perpetrated on Hoosen. Naidu counted between 60 to 75 individual discrete lesions or body wounds. He said there could have been around 120 strikes, although 60 of them fell below the wounding threshold. Many of these wounds/lesions are in clusters and groups which may have occurred in single impacts or with repeated impacts to the same body part. Strikes such as open-handed slaps to the face would not pass the wounding threshold and would not produce a visible injury. According to Naidu, these injuries around the elbows and knees appear to suggest a distinct quote-unquote pattern or set of patterns that are difficult to reconcile with usual causes of injury. They indicate a specific directed application of force, strongly suggesting restraint or constraint by an object or surface with a patterned configuration. Naidu stated that the possible use of electrodes cannot be excluded or easily dismissed. The injuries of the lower back do not reconcile with incidental injuries of falls, sliding on the ground, or being forced into a vehicle. The linear marks at the back of Hoosen's knees indicate the possibility of him having been suspended from a piece of wood under his knees. Naidu was of the view that the general wound age was at widest range between 6 and 24 hours, but that there was concurrence of a period of between 8 and 12 hours, which was the most likely. This placed the age of the injury squarely within the period Hoosen was being interrogated. Naidu was critical of Gordon's view on the injuries. Gordon viewed the injuries as superficial and refused to comment on how the injuries were caused and the type of force used. Naidu found that such an approach was unhelpful to the court and unbecoming of a senior state pathologist. Following the provision by Gopal of his affidavit, Naidu was asked by Advocate Shabnam Singh of the NPA to prepare a supplementary report that considered Gopal's version of the abuse of Hoosen. That report is dated 24 February 2021 and was entered as Exhibit L5. Pursuant to that report, Naidu made the following remarks. A, the nature of the assaults as described by Gopal are very much aligned with the injuries noted in the post-mortem examination. B, the nature of the assaults is also in keeping with his observations of multiple impacts in multiple positions and in keeping with the estimated age of the injuries of between 8 and 12 hours before death. C, the deep scalp bruising could have occurred with any type of blows, including Hoosen striking his head against the wall when he was plunged into the toilet. D, the number of injuries in clusters around the elbows and knee suggests the possibility of shackling, as mentioned by Gopal in his affidavit, when describing the practices of the security branch. E, the injuries behind Hoosen's knees raises the possibility that he was subjected to the helicopter method, while Gopal was not in the room. F. There were no genital injuries observed by Gordon in his post-mortem report, but unless one specifically dissects and looks for bruises, they may easily be missed. G. The abdominal blunt blow, as well as the chest bruising, could be in keeping with the possibility that a mule kick was administered to Hoosen. H. Gopal's description of Hoosen being in pain, exhausted and unable to stand and speak properly is in keeping with his assessment of what Hoosen's state would have been. Dr. S. Holland. Holland is the principal specialist in forensic pathology at the Diepkloof Medical Legal Laboratory. She prepared a specialist report on Hoosen's death dated 27 February 2020, which is Exhibit G28. According to Holland, the injuries on Hoosen's body were not related to the cause of his death. Holland noticed a large scalp hematoma over the top of Hoosen's scalp. She believed that it was caused by a blunt force impact to the head that may have occurred just prior to death. Hence, the possibility that Hoosen was incapacitated prior to death must be taken into consideration in determining the circumstances of his death. Holland cautioned the explanations given by the various police members in their testimonies at the first inquest, citing quote-unquote scuffles as the reason for Hoosen's injuries. Holland stated that such injuries were inconsistent with the findings of Magistrate Blunden. Instead, she stated that the unexplained injuries of the limbs should raise the suspicion of homicidal death. Holland agreed with Knight that it was a possibility, based on the post-mortem report, that Hoosen suffered thoracic contusion following a heavy blow to the left lower chest, which could lead to cardiac concussion. She also agreed with Knight that it is a blunt force injury that caused the injuries on the intestines. And she also agreed that the extravasation was limited. Holland, however, did not see evidence of electrocution, nor evidence of hypoxia or of brain injury in the report. She did concede that it was a possibility, but could only rely on the post-mortem report. From the foregoing, I'm implored to find that Hoosen was indeed tortured during his period of detention. The submission is meritorious since there is an eyewitness's account by Gopal, factual account, and forensic evidence to support the same. Hoosen was found, inverted commas, hanging in his cell with a trouser around his neck. The trouser was tied to the lowest rung of the cell grill. The crotch of the trouser was around his neck, and the trouser was twisted to create the compressive force. The ends were tied around the grill in a knot. A handkerchief was then tied over the knot. I'll deal with Tivash's evidence. Tivash is a mechanical and aeronautical engineer with the firm TMI Dynamatics. In 2018, he was requested by Singh to conduct simulations and report on the death of Hoosen. His first report, dated 6 April 2018, is before this court as Exhibit G25. The photographs taken during the simulation are contained in Exhibit G25.1, while his final report, dated 6 August 2019, is Exhibit G25.2, and the video of his simulation is Exhibit G25.3. The final report includes the report of the simulation conducted in relation to death by suffocation. Tivash concluded that it was possible, but unlikely, that Hoosen died from self-strangulation. Tivash first considered the magistrate's finding that Hussein, quote unquote, died by hanging. He observed from the photos that Hussein's legs, pelvis, and abdomen were on the floor. The noose was fixed around the lower section of the neck. The height of the knot on the first horizontal bar of the jail door was 493 millimeters above the ground. Only the head, thorax, neck, and upper arms were suspended off the ground. He noted documented findings that a person would need approximately 15 kilograms of compression of force around the neck to block their arteries and cause death. Hussein had a tall frame at 1.75 meters, but weighed only 49 kilograms. He concluded that the tensile force in the trouser is equivalent to a suspension mass of 11.72 kilograms, which is approximately 24% of Hussein's total weight. He was of the opinion that the suspended mass was too low for Hussein to have died from hanging or sudden arterial occlusion. Tivash and his team conducted simulations.
My Lord, sorry to interject. I think the brother of Dr. Haffejee has fallen ill during the course of the lunch break.
I'm sorry.
He was coming into court, but he stumbled on the step and fell.
Okay.
It seems that we're having some medical complication at the moment. Maybe just
I'll take a short break.
as a conclusion.
Okay. Court is adjourned.
But even so, we need to get so maybe we should just get an ambulance.
You're gonna hear about this. But the point is, you haven't got any other matters up. Just, there was just
And besides,
deal with that shit.
I know that.
Yeah.
He can avoid that person.
Not even the family doesn't believe either. They just see the face.
100%.
And then it's like, oh,
No.
so it doesn't make a lot of problem.
Thank you, David.
Okay. Sit. Let's get going.
We go to it half an hour.
Yeah.
So we are
20 more pages. 1 hour. 20 pages, 1 hour.
yeah, I think we do. If I may, we just want to thank my Lord for having stood the matter down to give Mr.
Yeah.
Ismail the opportunity to go to the doctors. He's been taken by ambulance, Your Worship.
Okay.
The family has indicated that they would like for us to continue
Okay.
with the judgment. Thank you, my Lord.
Thank you. I proceed. Sivash and his team conducted simulations dealing with 4 scenarios. He concluded that the two of the scenarios were within the realm of possibility. In scenario 1, A, Hoosen tied the ends of the trousers to the lower vertical bar of the jail door grill, and then tied the handkerchief around the knot and placed the crotch of the trousers around his neck. B, he then turned himself until the pants were twisted so tight around his neck that he suffocated and died. A fourth or fifth turn would have likely resulted in suffocation. C, the reenactment demonstrated that it would have been considerably easier for Hoosen to twist the trousers around his neck by rotating his head whilst kneeling in front of the jail door. D, however, it is likely he would have been suffocated and died in a kneeling position. To have been found in a lying position, he would have to stretch out and lie down while in the process of suffocation. In the second scenario, which was scenario 4 in the simulation, A, third parties placed the crotch of the trousers around the neck of a live or an already deceased Hoosen. B, then twisted the trousers. C, then pulled Hoosen to the door and tied the trousers to the lowest horizontal bar of the jail door. D, tied the handkerchief to the knot of the trousers to ensure the trousers cannot be untwisted. And E, then closed the door and exited. Thivash noted that it was the first time he had seen a handkerchief being used to secure a knot. He stated that the handkerchief was used to make sure that the knot of the pants would not slip open. It was also to maintain the compression force when the pants twisted. If the knot of the pants loosened, compressive force in the pants would have been lost. Regarding the staged suicide scenario, Thivash said that the third parties could have tightened the ligature without necessarily having to roll the body over, because they would twist it in their hands while the body was in a complete stationary position. Thivash was of the view that it was likely that a third person was involved because, as I quote, it could be very easy to use the lowest bar, strangulate the person, tie them to the lowest bar, and then close the door behind them, close quote. Thivash noted that the position in which Hoosen's body was found would have made suffocation difficult to achieve. So it was suggested that third parties may have been involved in his death. If there was no involvement of a third party, it would have involved great effort to have suffocated himself in that position, and he would have chosen the most difficult position to suffocate himself. If suffocation as opposed to hanging was the preferred option of suicide, Thivash maintained that it would have been immeasurably easier to kneel or stand up since, quote, you would require a lot less rotation of the body on the ground, like twisting on the floor, and you could literally stand up straight and just turn around in a direction to keep twisting that knot, close quotation. In his report, during the inspection in loco as well as his testimony, Thivash said the entire situation intrigued him, since the cell door was approximately 2 meters high. It would have been immeasurably easier to commit suicide by simply hanging oneself from the highest bar. This would have allowed his entire body to be suspended. This is especially so in light of the version advanced by all the police officers that Hoosen was able to walk with ease from the church office to the cell. According to Thivash, even hanging himself from the second or third horizontal bar of the grill gate would have been an easier method of suicide because more body weight would have been suspended than just his head and shoulders. Aside from higher vantage points on the gate grill, Thivash noted that he had the option of attaching the ligature to the higher parts of the cell door or on either of 2 windows that were available. In this regard, see photos numbers 22, 23, 27, and 28 of the inspection in loco report. Thivash found it to be weird that a person would choose the convoluted maneuver involved in strangling oneself from the lower bar of the door. Thivash agreed that if the death was the result of homicidal strangulation, then rigging the deceased to the lowest rung of the ground was the quote-unquote simplest and easiest method. That is so, since if higher rungs were used, the deceased would have to be lifted, requiring 2 or more persons to hold him and another to tie the knot. Also, it would have been simple enough for the perpetrators to step out of the cell and then just pull the door behind them. Gopal considered in cross-examination that Hoosen was too weak to have crouched or rolled around to strangle himself. He added that if Hoosen was able to stand and walk, and if he intended to commit suicide, he would most likely have done so from the highest rung of the cell bar or from the grill on one of the cell windows. If the suicide was staged, Gopal agreed that it would have been easiest to attach Hoosen to the lowest rung on the cell door because it meant no lifting and no holding him while carrying out the maneuver. In support of Thivash's view that third parties were most likely involved in causing the death through a staged suicide was the expert opinions of 2 forensic pathologists who testified in the inquest. They raised the distinct possibility that Hoosen was incapacitated prior to death. The 2 pathologists are Holland and Naidu, who noted serious injuries caused by a blunt force impact to the head, which either led to unconsciousness or a lowered state of consciousness or a drowsiness as seen with concussion. Naidu also noted that thoracic contusion is indicative of blows to the left lower front of the chest, which would also cause the person to be winded, breathless, and in pain. Such a blow could also cause cardiac concussion. Also, to be factored in are abdominal injuries arising from the mesenteric extravasation of blood, which would have seriously incapacitated Hoosen. As indicated earlier, Naidu was of the view that such a massive abdominal blow would have been potentially life-threatening if the spleen or liver had been damaged, and death may have supervened shortly thereafter. So, the medical evidence suggests that Hoosen was most likely incapacitated prior to death and would have been in no position to carry out the strenuous exercise of strangling himself as alleged by the police. Naidu even questioned the need for an additional knot with a handkerchief over the trouser, which he viewed as somewhat redundant and superfluous, especially since the legs of the trousers were of, quote-unquote, ample length to tie a knot. He commented that the knot appeared to have been extremely tight, as observed by Gordon, who was at the death scene. In this regard, he referred to the report by Robert Chisnell's MED, MED titled, and I quote, Distinguishing Between Homicide and Suicide Notes and Leakages, a comparative analysis of case and survey data, close quote. Naidu considered the findings of Chisnell in a short commentary which was made available to the court and the parties. While noting that he was not a knot expert, Naidu drew attention to the finding that strangulation was, quote-unquote, more likely in external tying cases and, quote-unquote, not likely in self-tying. He noted that Chisnell's article did not consider ligature twists, a number of twists, but did investigate ligature tension and found A, and I quote, in all homicides involving strangulation with knotted ligatures, the neck ligatures were tight or extremely tight, smaller than the relaxed circumference of the neck, close unquote. B, suicides were more frequently characterized by loose neck ligatures and the presence of an inverted V mark in the soft neck tissue. C, the incidence of tight, self-tight neck ligatures was lower than loose ligatures. Naidu noted that there was no presence of an inverted V mark, which is the typical hallmark of a suicide. According to Gordon's post-mortem report, the official cause of death was quote-unquote consistent with hanging. According to Biggs' report, it seemed likely that Hoosen's death was caused by a tight constriction of the neck. It further appeared to be death by suffocation rather than by sudden arterial occlusion. He explained that this was because the knot was so tight that it had to be cut open. Naidu concluded that the cause of death may have been the consequence of pressure upon the neck, arising from the consequence of neck constriction by ligature or ligature strangulation. He excluded actual hanging by suspension. Naidu found that possibility of quote-unquote terminal reflex neurogenic cardiac arrest cannot be excluded. He noted that it was also a possibility that such cardiac arrest could have occurred under torture. According to Naidu, if Hoosen had died following cardiac arrest, this would not have been picked up at the postmortem, as there would be no signs that this was the mechanism. While Naidu accepted that neck constriction could have been self-applied, he found it odd that the deceased attached himself to the lowest rung and not one of the upper rungs of the cell door grill, which would have made self-constriction easier. He testified that he had seen several examples of suicide by self-constriction from a standing position, and that this case was the first time he had seen an alleged suicide employing this method so close to the floor. He found the ligature contraption on Hoosen to be extremely unusual. He could not determine whether this was a self-inflicted neck constriction or whether it was caused by another party. The available objective evidence does not exclude other persons applying the constriction. Naidu, however, excluded throttling, which he defined as the manual strangulation by hands or fingers, as opposed to the use of a ligature. In relation to the short linear abrasion on Hoosen's neck, contrary to Gordon's repeated claims that such injuries are usually due to the deceased's own fingers and fingernails attempting to adjust the ligature in suicide, it appears unlikely that a person intent on committing suicide would have a reason to adjust the ligature in the process of suicide. Such adjustments to loosen the constricting ligature likely happen in instances of homicidal strangulation. Naidu concluded that it, open quote, cannot be resolutely determined that the ligature constriction of the neck was caused either before or after death or before or after a state of unconsciousness has occurred, close quote. Naidu disputed Gordon's assertion that the possibility of postmortem hanging, or more accurately constriction, is quote-unquote completely excluded. Naidu noted that except for 2 areas of bruising on the neck, at the inner aspect of the right side of the mandible and the anterior edge of the sternocleidomastoid muscle, no other deep vital reaction was observed. Accordingly, both hemorrhages could have been postmortem, as much as they could have been perimortem or antemortem. Naidu testified that there was no way a pathologist could say, and I quote, that the ligature was not placed after death or constricted, or if the person died before, or whether he was still alive and the ligature was placed, or he placed it himself, close quote. The 2 bruises referred to above, he said, and I quote, are more likely related to the ligature itself. They are superficial, close quote. And such bruising, open quote, can be seen in some cases where a person is strung up very shortly after death, close quote. Holland concluded that the cause of death, based on the findings documented in the postmortem report, ought to have been, quote-unquote, consistent with pressure to the neck. She highlighted that the postmortem report indicated that examination of the internal neck structures showed, open quote, bruising of the subcutaneous tissues below the inner aspect of the right side of the mandible, close quote. She stated that an assessment of the presence and shape of the ligature mark is the most crucial factor in determining a case of, quote-unquote, hanging versus a case of strangulation. She concluded that A, the presence of marks in the internal neck structures of Hoosen were not consistent with hanging. B, since a pair of trousers were allegedly used as a ligature, such material is a quote-unquote soft, broad type ligature, which would not be expected to cause injuries to the neck. C, the presence of submandibular, which is the site of the jaw under the ear, bruise is not consistent with hanging, but usually indicates blunt force applied directly to that area and is more consistent with the manual application of pressure to the neck, that is, manual strangulation. Holland noted that the postmortem report described at least 46 quote-unquote abraded bruises on the back, groin, both arms, and both legs. Histological analysis on some of these wounds was done from the back, right groin, right knee, and base of the neck, which suggested that the wounds were between 4 and 12 hours old. She stressed that these wounds displayed a quote-unquote vital reaction, confirming that they were sustained during life. As explained earlier, she disputed the magistrate's finding that the injuries were not related to cause of death and that they did not need to be explained. In her view, explaining these injuries was, quote-unquote, crucial in excluding or confirming a homicidal manner of death. Holland noted that since Hoosen only weighed 49 kilograms, it would not have taken much for multiple security branch officers to subdue him. She noted further that untangling of hair in the knot of the ligature, as was the case here, is generally associated with homicidal hanging. I turn to the time of death. According to Gordon, the probable time of death was between 03 hours and 4 hours in the morning. He examined Hoosen's body at 6:59 and recorded his temperature at 35.3 degrees centigrade. He used a method which calculated the time of death by using a decrease in temperature. He claimed that his estimation of the time of death was based on, quote, the collation of the temperature and rigor mortis and the lividity and so on. It hasn't got absolute accuracy. It can't possibly have, but it is an estimate, close quotation. Neither disputed the finding of Gordon. He was of the view that death occurred several hours earlier, possibly around midnight or earlier. Due to the technical nature of the calculations, Naidu attached Annexure A, titled Notes on the Estimation of Time Interval since Death, close quote, to his report to explain his conclusions. Naidu doubted the reliability of core body temperature as an accurate measure of time of death. The reading of 35.3 degrees centigrade at 6:59 at the death scene was approximately 1.7 degrees lower than the assumed rectal temperature of 36.9 degrees centigrade. Naidu noted that in theory, it is assumed that the normal core temperature is 37 degrees centigrade and there is a post-death temperature plateau of between 1 and 2 hours. And thereafter, there is a steady post-mortem temperature drop of approximately 1 degree centigrade per hour. Using the first temperature reading of 35.3 degrees centigrade, this is a 1.7 degrees drop from the normal core temperature. This must be added to the plateau, which extrapolates between 2.7 to 3.7 hours since death, which is close enough to Gordon's estimate. However, this method does not take environmental and other conditions into consideration and is a very rough rule of thumb process. If the formula is applied to the temperature reading of 27 degrees centigrade, which was recorded at 10 hours 23 at the beginning of the autopsy, the rough calculation would be an interval of some 11 to 12 hours since death. This would bring the time of death between 22 hours 23 and 23 hours 23 the night before. Naidu applied the most stringent quote-unquote, Hoosen's nomogram method to Gordon's first and second temperature measurements, employing average environmental temperature of 18.5 degrees centigrade, and arrived at the result of a time lapse of 7 and 11 hours, respectively, since death. Naidu viewed the state of full development of rigor mortis as a more reliable measurement of the time of death. Gordon's findings in Annexure D of the postmortem report was that rigor mortis, quote-unquote, had developed completely and fully developed in all the joints he described. Naidu concluded that complete rigidity happens between 6 to 10 hours after death, with a mean at 8 hours, relying on the well-researched text of Hoosen. In his testimony, Naidu narrowed his estimates to time of death to be between 2200 hours and midnight, with a possible mean of 22 hours 50. He concluded that the evidence given in the first inquest by Node and Madlala, who claimed to have seen Hoosen alive at 03 hours and only dead at 04 hours, must be, quote-unquote, seriously doubted and challenged. In a report, Holland noted that in the postmortem report, the postmortem interval, PMI, was stated as, quote-unquote, 3 to 4 hours. However, she noted that Gordon only considered the changes in the body temperature to assess the PMI. This contrasted with Gordon's scene report, which described that the upper limbs and the lower limbs were in full rigor mortis. Relying on the research of Shroom and Ramsay, she noted that the time rigor mortis is established in all joints varies from between 2 to 20 hours, with a mean 8 plus, minus 1 hour. Referring to Soko and Knight, she noted that rigor mortis in average conditions might be expected to reach a maximum within 6 to 12 hours. The finding of full rigor mortis in the large muscles, like the upper and lower limbs, would significantly increase the PMI. Holland concluded that the longer PMI was not consistent with the explanation of the circumstances of death as given by the police witnesses in the first inquest. If the evidence of the two forensic pathologists is accepted, then Hoosen died while in the hands of the security branch, that is, under interrogation. All the police officers who testified in the first and reopened inquest insisted that Hoosen died in the cell number 2 at Brighton Beach Police Station sometime after he was locked up around midnight. The church office members who were present claimed that Hoosen died between 03 and 04 hours in the morning. Their evidence is in direct conflict with the expert evidence of Naidu and Holland, who asserted that Hoosen must have died several hours earlier. Gopal insists in his evidence that Hoosen was alive when taken to his cell at midnight and that he was likely murdered in his cell sometime thereafter. Gopal asserted that the evidence of Nutia and Maya ought not to be accepted because they would have collaborated with whoever inflicted the injuries on Hoosen in his cell. Gopal appeared to be adamant that Hoosen did not commit suicide but was murdered. This was because Hoosen was strong psychologically and did not break down in interrogation. He was very thin, and after being beaten, he was weak. And it was suspicious that Major Benjamin shushed him when he inquired about how Hoosen died. The security branch would not go to such lengths if it was actually suicide. It appears then that Gopal accepts that Hoosen was murdered and did not commit suicide. However, he insisted this did not take place in his presence. Notwithstanding the conflict between Gopal's version and the views of the aforesaid pathologists, Gopal and his lawyer did not seek to rebut such evidence with their own expert report, nor was any application brought to re-examine Naidu and Holland. The legal team for the family carried out an exercise to align the age of Hoosen's injuries with the possible times of death. In this regard, Holland and Naidoo did not challenge the age of the injuries in the histology report attached to the postmortem report. The histopathological investigation estimated that the ages of the injuries were between 4 and 12 hours before death. Gordon claimed that Hoosen died between 03 and 4 hours in the morning. If we do the subtraction of 12 hours, the outer limit or the earliest time that the injuries could have taken place on Gordon's estimation of death at 4 hours in the morning would have been 1600 hours in the afternoon. If death occurred early, say at 3 hours 30, then the earliest injuries could only have taken place at 15 hours 30. Holland and Naidoo both concurred that based on the assessment of fully developed rigor mortis, that death had occurred between 6 and 12 hours prior to the declaration of death by Gordon at 6 hours 59 in the morning. The mean time would have been approximately 8 hours, working back from that time. On their estimations, the latest time of death would have been at 01 hours in the morning, and the earliest time of death would have been at 1900 hours the night before. The mean time of death would have been at 2300 hours the night before. If one takes the mean time of death as being 2300 hours and subtract 12 hours, then the earliest injuries would have taken place at 11 hours the day before, or the same day, the day before that is. If we subtract 4 hours from 2300 hours, then the latest time injuries were sustained was at 1900 hours. So, on the mean time of death, we have injuries being inflicted between 1100 hours and 1900 hours. It is thus submitted by counsel for the Haffejee family that this appeared to be an acceptable range because it is consistent with Gopal's evidence in the statement and his testimony. If one takes the latest time of death as 01 hours and we subtract 12 hours, that takes us to 1300 hours. This would not accord with Gopal's evidence that Hoosen received serious assault at least from mid-morning. On Gopal's version, at about midday, Hoosen was already doubled over in pain. So, the infliction of serious injuries must have taken place well before 1300 hours, which means he could not have died at 01 hours in the morning. If one takes Naidoo's report, when he considers the time of death based on core body temperature measurements, his calculation is that the time of death was between 2200 hours 23 and 23 hours 23. If one subtracts 12 hours from 22 hours 23, that gives us infliction of serious injuries at 10 hours 23. But if we subtract the 4 hours, that gives us 18 hours 23, which seems to accord with Gopal's evidence. If the time of death was at 23 hours 23, then you get the earliest infliction of injuries at 11 hours 23 and the latest at 19 hours 23. The expert evidence on the question of time of death also materially contradicts the evidence of the church office personnel, i.e. Maya, Nodi, and Madlala. It is submitted by the family's counsel that the court must accept the evidence of the 2 forensic pathologists which has not been rebutted. It is also submitted that Gordon made fundamental errors in his postmortem report, most notably in relation to time of death, and that it must be asked whether Gordon was simply incompetent or whether he, like Magistrate Blunden, was politely averting his gaze. On returning to the police cover-up, the aspect already dealt with earlier, it is Marion's strong opinion and view that the SAP investigation was not only substandard, but aimed at concealing what really happened between 2 and 3 August 1977. In his scathing assessment of the investigations carried out, he found that the minimum standards of investigation were not adhered to in regard to the whole investigation, from the crime scene, collection of evidence, identification of potential witnesses, going right through to the securing of the exhibits collected. In his opinion, the shorty investigations were a deliberate attempt to cover up the truth about what actually happened. The investigation was fixated at covering up the crime committed. Evaluation. What appears not to be in dispute are the approximate times of Hussein's arrest, arriving at Brighton Beach Police Station, and the commencement of the interrogation. Hussein's interrogation seems to have commenced between 9 hours 20 and 9 hours 35. These involved open palm slaps, punches, and kicks. It seems to have gotten progressively worse from 10 hours and continued into the evening. Gordon's estimate of time of death must be dismissed because of his estimate the earliest injuries would only have taken place between 1500 hours and 1600 hours, which does not accord with Gopal's account. Gopal's version of torture is the only version available and cannot be jettisoned simply because he might not be seen credible on other aspects. I'm, however, not going to dissect his evidence to expose such disconcerting aspect as one would do to establish guilt beyond reasonable doubt in a criminal trial. Suffice to say that his testimony was believable on multiple points of torture, and he probably downplayed the extent and his role in it, as he seemed to distance himself from other unrelated interrogations of political detainees as being merely an observer. His version regarding Hussein's torture is largely supported by credible medical evidence tendered by the medical experts, although his version did not get to explain, for example, the burn marks seen on Hussein's body by pigs. The main issue to be determined is the cause and time of Hussein's death. Time of death becomes paramount because from it one can infer at what stage Hussein might have died. Although suggested times of death are varied, one can work out the most likely time of death, taking a cue from Gopal's testimony and working on the uncontested histological evidence which placed the ages of the injuries at 4 to 12 hours before death. What emerges from the objective evidence is that Hussein was killed much earlier than postulated or claimed in the police testimonies. His death was then followed by an elaborate scheme devised or designed by the police involved to cover up the cause of his death, which death was likely to have been directed or carried out with subjective foresight. The estimated mean time of death of 2300 hours by Nadu puts the earliest injuries occurring at 11 hours and is aligned with Gopal's time of when the terrible abuse was inflicted. Naidu's estimate of time of death, based on temperature reading at 2200 hours 23, which brings the earliest inflicted injuries to 10 hours 23, is even closer to Gopal's account of when serious assaults began. Therefore, the most probable time of death was between 2200 hours 23 and 2300 hours on the night of 2 August 1977. One would be stretching it too far to put the time of death at 01 hours, 3 August 1977, simply because it does not accord with rigor mortis findings made by the forensic pathologist. That means Hussein died while in the hands of the security branch of either cardiac concussion during interrogation or of cardiac arrest from neck constriction in the cell. If Hussein died during interrogation, which cannot be excluded, it means suicide was staged to mask the death under torture. That is very much a reasonable possibility in view of the cover-up, since there would have been no need of one if he died through a genuine suicide. If he was still alive, as Gopal asserted, apparently barely alive from long, barbaric, unrelenting, extensive torture when he was lodged in the cell, I find that his death in the cell was not as Magistrate Blunden found, self-induced or suicide. He was most likely strangled/strangulated by third parties, none other than his torturers, using his garment. Taking from Thivashi's reliable testament, the security branch members' elite and fiat status, which gave them full access to the cells anytime, and applying sheer common sense, it seems improbable in the extreme that Hussein committed suicide by strangling himself to the lower rung of the grill while in the cell alone. Hussein appeared to have been a religiously and politically principled man who stuck to his principles through thick or thin. This apparently is what enraged his interrogators, even more as he was not, as Gopal stated, forthcoming with information useful to them. Such extrajudicial killings and cover-ups were the order of the day during the apartheid-era policing methods. Therefore, what the police conjured up in their testimonies must be rejected. They could not even explain about the garments which Hussein died wearing. Clearly, it must have been garments they provided to him for reasons best known to them before he died. There is also no evidence of an occurrence book entry to show that he was lodged in the cell at midnight, or indeed at all. Whether Hussein died, quote-unquote, on the table or in the cell, as it were, one thing is very clear, and that is that the security branch officers who were involved in his kidnapping and torture were very much responsible for it. It does not matter that possibly a few had to do the dirty job of physically torturing him as others present assisted. It was teamwork, and all those present participated in one way or the other. Counsel for Gopal submitted that Gopal was merely a bystander or an observer. I do not agree, since his evidence does show that he played a role, minimal or minimized as it may have been, but nevertheless a positive one, and he thereafter conspired to conceal the truth. He may not have pulled the proverbial trigger, but he participated in a common design to round up, interrogate, assault with intent to extract information, acting together with his colleagues. The extent of the assaults clearly shows that the interrogators and those assisting them must have foreseen, and by inference did subjectively foresee, that death would or might follow. Despite this fact, all of them went ahead with their unlawfully designed objectives and reconciled themselves with the foreseen consequences, or were reckless of the fatal consequences that could flow from it. Counsel for Gopal also submitted that up until September 2021, Gopal was under the impression that he would be used by the state as a 204 witness against his colleagues who tortured Hussein. She contends that if common purpose was permitted to apply to him, he would not have the right to a fair trial, as he was initially promised the protection of being a Section 204 witness. As a result, it was argued, he forfeited his constitutional right to remain silent and not incriminate himself. Obviously, one is not dealing with a criminal trial, and these proceedings do not attract the Section 204 provisions. I therefore cannot decide his fate based on those provisions. Findings and recommendations. I have established that there are sufficient reasons to set aside the original inquest finding. This court is now required to determine whether there is a prima facie evidence before it upon which a reasonable person might convict a person of an offense arising from Hussein's death. The ultimate decision, whether to prosecute or not, will rest with the Director of Public Prosecutions after the record of the proceedings is referred to her in terms of sections 17(1)(a) and (b) of the Inquest Act. In Freedom Under Law versus National Director of Public Prosecutions and others, Murphy J. aptly held as follows regarding the purpose of an inquest and what should ideally follow after a finding has been made. And I quote, "An inquest is an investigatory process held in terms of the Inquest Act, which is directed primarily at establishing a cause of death where the person is suspected to have died of other than natural causes. Section 16 in brackets 2 of the Inquest Act requires a magistrate conducting an inquest to investigate and record his findings as to the identity of the deceased person, the date and cause or likely cause of his death, and whether the death was brought about by any act or omission that prima facie amounts to an offense on the part of any person. The presiding officer is not called on to make any determinative finding as to culpability. The only question for the magistrate in terms of Section 16.2 of the Inquest Act was whether the death was brought about by conduct prima facie amounting to an offense on the part of any person. A prima facie case will exist if allegations as supported by statements and real documentary evidence available are of such a nature that if proved in a court of law by the prosecution on the basis of admissible evidence, the court should convict. In Rico, New and others, the court held that the standard of proof required to make a finding in an inquest is not that which is applied in a criminal trial. The test is less stringent in inquests. The court explained this rationale as follows, and I quote, "Bearing in mind the object of an inquest, it is my opinion that the test to be applied is not the what quote-unquote beyond reasonable doubt test, but something less stringent. In my opinion, the test envisaged by the Inquest Act is whether the judicial officer holding the inquest is of the opinion that there is evidence available which may at a subsequent criminal trial be held to be credible and acceptable, and which, if accepted, could prove that the death of the deceased was brought about by an act or omission which involves or amounts to the commission of a criminal offense on the part of some person or persons. I therefore make the following findings. 1. The finding and judgment of Magistrate T.L. Blunden, dated 15 March 1978, in inquest number 951/77 is set aside. 2. The cause of death of Dr. Hoosen Haffejee is attributable to either of the following possibilities. A. Hoosen died following a cardiac incident while under torture. Alternatively, B. Hoosen died from a cardiac incident caused by ligature constriction applied by the security branch members either while less conscious, unconscious, or debilitated after torture. 3. Time of death was not in the early morning, but late on the night of 2 August 1977. The most likely time ranged between 2223 and 2300 hours. 4. The security branch officers primarily responsible for torturing and murdering Hoosen are Captain Petrus Lodevicus Dutoy and Lieutenant James Bro Taylor. 5. While Dutoy and Taylor played the leading roles in causing the death of Hoosen, those who played various other roles in the interrogation, torture, and cover-up must also be held responsible for acts connected to Hoosen's murder. They associated themselves with what happened to Hoosen and did not raise the alarm. These persons are A. Brigadier Steenkamp, Commander of the Security Branch Durban. B. Colonel Ignatius Gerard Kutsie, 2IC, Security Branch Durban. C. Major Joseph Benjamin, formerly Munsami. D. Lieutenant Vic McPherson. E. Warrant Officer Shunmugan, in brackets Screws, Governor. F. Sergeant Viera Ragalulu Naidu, VR Naidu, and G. Mohan Deva Gopal. The former SAP uniform branch members stationed at Brighton Beach Police Station, who turned a blind eye and helped to facilitate the security branch cover-up, defeated the ends of justice and are accessories after the fact to murder. They include former constables Johannes Nicholas Meyer, Derek Hugh Nodier, and Shadrach Madlala. As stated earlier, Dutoy died on 15 April 2008. Taylor died on 19 August 2019. Vic McPherson died on 20 April 2017. and Joseph Benjamin died on 16 December 2010. Except for V.R. Naidu and Gopal, all other security branch members have either died or could not be traced, while of the church office uniform branch members, Madlala has passed on. It is thus recommended that certain charges be considered by the National Prosecuting Authority against the following persons. 1. Surviving members of the security branch, Mohammed Deva Gopal, murder by common purpose and possibly telling lies under oath in his testimony, that is perjury. B. Viera Rakalulu Naidu, further investigations to be done to establish whether he was present or establish his whereabouts during the periods of Hussein's interrogation and death, with the view to include or exclude him in the matter by association. 2. Derek Hugh Node and Johannes Meyer, accessory to Hussein's murder, from participating with the security branch in the cover-up and giving false testimony before the first inquest, and be investigated for perjury in providing multiple false statements under oath before this court, knowing them to be false with regard to Hussein's physical state, this, to which they referred as perfect health, and in the handling of cell number 2 keys. Mati Vatini Benjamin, perjury for giving false testimony under oath with regards to e.g. finding bits of metals and nails that look like shrapnel, for bombs while cleaning Hussein's flat, denying giving security branch members a key to Hussein's flat, denying meeting Gopal and other members of the security branch at Delhi restaurant, denying being entertained with booze and cash by the security branch members, and claiming to having been threatened by the Haffejee family after Hussein's death. Without her handing over Hussein to the security branch, he possibly would still be alive today, or would have progressed in his profession, spent a long quality life with his family, and possibly made more invaluable contributions to our hard-fought freedom and democracy. However, her demeanor during her testimony appeared entirely unrepentant. In conclusion, may I convey my deep gratitude to all counsel involved for their invaluable and professional hard work to get this reopened inquest concluded and the truth be exposed to afford the Haffejee family some semblance of closure. I am advised that there are many more families awaiting the inquest of their loved ones to be opened or reopened to get to the truth of how they died while in the security branch detention. In the KwaZulu-Natal list, we can mention the names of Joseph Masobila Mdluli, who died at the Durban Security Branch Fisher Street offices on 19 March 1976, allegedly from falling against a chair and hitting his head and chest on a door. Samuel Malinga, who died at Pietermaritzburg prison on 22 February 1977, allegedly from natural causes. Aaron Khoza at Pietermaritzburg prison on 26 March 1977 from alleged suicide by hanging. Bayempini Mzizi at Brighton Beach Police Station on 10 August 1977, allegedly from suicide by hanging. And Ephraim Mtetwa at Durban Central Prison on 25 August 1985, allegedly from suicide by hanging. With regard to Bayempini Mzizi, I am advised that attempts were made to also reopen his inquest and consolidate it with this inquest, but it has not happened since there was still no decision taken in that case. I conclude the judgment.
As a court, please, my lord. My lord, if I may, just wish to express, and my lord will recall this morning in chambers when I indicated that my learned counsel, Howard Barney, was not available, unfortunately, as much as he'd love to have been here.
Yes.
Circumstances dictated that he was not able to.
Yes.
But I'm certain on his behalf, I would also like to express our gratitude to your lordship for the manner in which we've dealt with this particular matter. Secondly, my lord, I have specific instructions from the family of Dr. Haffejee to express their gratitude to your lordship, to counsel for the state, and for every other individual that made this inquest possible. It was a long road. It took years of preparation and gathering of information and evidence, my lord. And it has taken 46 years for this family to finally get the closure that they deserve. And it is sad that over the years, they've lost their parents and siblings and so on. And they carried this pain and heartache and trauma throughout their lives. And at this late stage in their lives, we can at least say we're grateful for one thing, that is that they indeed have some degree of closure, Your Lordship.
Yes.
So with that, I also want to express my gratitude to Your Lordship. Thank you, my Lord.
It's not a thank you.
Thank you.
Mr. Chamber, is that all? Court is adjourned.